manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good afternoon, everyone. We'll hear first in 21765 Berg versus the Kingdom of Netherlands. Mr. Woofter.
Good morning, Your Honors, and may it please the court. I'm Daniel Woofter, arguing on behalf of Plaintiff Appellate Berg in this matter. This is a rather complicated case with a lot of issues, so I'll start by laying out what I think is the minimum that this court would have to do for my client to obtain a remand in this case. First and easiest, to remand this case as to the public museums and the artwork in their possession and control, I need only to convince this court of two things on which the district court erred. One, my client had standing in fact since the outset as either the heir or personal representative of Katz, and it is more than plausible that a judgment against the public museums could fully redress at least some of my client's claims. And two, to the extent the Constitution might require something more than what Congress said in the FSIA establishes personal jurisdiction, the public museum's specific contacts in the United States involving the exact artworks at issue are more than sufficient to establish specific personal jurisdiction over the public museums. Second, to remand this case as to the ministry and RCE, thus keeping all of the subject artwork in the case, I need to further convince this court that one, the ministry and RCE are agencies and instrumentalities because their core function is commercial, not governmental, or at the very least that defendants have not met their burden of persuasion to categorically disprove such at this pre-jurisdictional discovery stage. And two, that again, to the extent something more is required than what is necessary to establish personal jurisdiction under the FSIA, the ministry and RCE are also subject to specific personal jurisdiction here based on the allegations and evidence of their commercial activity in the United States involving the specific artworks at issue.
So, counsel, could I interrupt you right there? I'm just trying to make sure before we get into the arguments, I understand what's on the table and what's not. And I think with respect to the museums, you've identified the issues as I saw them, with one exception, which is the venue issue. And I know you weren't suggesting that wasn't present, but I think that issue is on the table as to the museums well. With respect to the ministry and RCE, I certainly understand that on the table we have the district court's determination that those defendants were political subdivisions, as opposed to agents and instrumentalities. Do we have, you mentioned just now the personal jurisdiction issue as it relates to those defendants, if I understood you, and I didn't, maybe I am not completely clear. Is that issue before us since the district court did not rule on that?
No, Your Honor, I agree with you there. And actually, I agree that the proper course, if you do agree with us that the ministry and RCE are agencies and instrumentalities, the better course would be to remand for the district court to then run a personal specific jurisdiction analysis as to the ministry and RCE as well.
Okay, and doesn't the standing issue applies to those defendants as well?
Yes, and I didn't mean to make it sound like all of the first issues I named did not apply. I just meant to say that those further arguments are the ones I had to convince you of as to the ministry and RCE.
I appreciate it. I wasn't suggesting you were trying to do anything other than I just wanted to make sure I was clear on what we have before us. So you can proceed. Thank you.
Before you proceed, can you address the issue that Judge Cladwell mentions with respect to the public museums? If I agreed that you had standing and I agreed that personal jurisdiction exists, why wouldn't venue still mean your case is dismissed?
Your Honor, I think that the primary consideration there is that the district court would have been required under 28 USC 1631 to consider whether or not to transfer the case rather than dismiss it, as it did. It did not have.
You didn't appeal that issue, right? That issue is not before us. So the district court's decision to dismiss is an unappealed decision of the district court. So we don't review that. And so that claim is dismissed. And so I'm having a little hard time understanding why I can even consider the public museum issues at all, because it appears to me that you haven't appealed the venue dismissal. And I understand your position that maybe it should have been transferred instead of dismissed, but you didn't appeal that.
Your Honor, I actually disagree with the defendants on this point. We have not waived venue, as we said in the opening brief, and I quote, because of the district court's finding of improper venue was based solely on its personal jurisdiction holding, its dismissal based on venue does not pass muster. But the more important point, I think, is that the district court did not actually decide whether, if its venue holding is correct, transfer instead of dismissal was appropriate. It had already held that plaintiff failed even to plead standing, and that curing that defect would be futile. So an error subject to reversal if this court agrees that there is jurisdiction over the museum defendants at the very least. So it would be for the district court in its discretion on remand to then decide, okay, well, there is standing, there is specific personal jurisdiction, and the FSIA has an exception that applies to the public museums. Now it is appropriate for me as the district court to decide in my discretion whether or not this case should be transferred because I believe venue is improper. And so that goes to the final point, which is that the rest of the issues, including whether to transfer the case, which the district court never had occasion to consider in the first instance, since it believed we did not have standing, would be to remand the case for resolution of any issue not reached, including whether the case should be transferred rather than dismissed. And that.
So I'm sorry, I want to make sure I understand your argument. It seems like you're making two different points. One, your position is the district court did not dismiss your case for venue.
My point is that even if the court dismissed it for venue.
All right, but so let me ask that question. Did the district court dismiss with respect to the public museums under the venue statute?
I believe the district court said that venue was improper and also a reason to dismiss. And yes, that is something that we challenged on appeal, saying that that was that its venue reasoning did not pass muster. And I would just, as one last point the district court to a recent Third Circuit decision, Danziger v. and Delano v. Morgan Verkamp. That's at 948 F. 3rd 128, where it says that the district court is required under the statute, even sua sponte, to consider whether to transfer a case rather than dismiss it under venue, because that's what the statute says in the text. The district court shall consider that.
But an appellant shall challenge any district court order that he wants reversed on appeal, right? I mean, the challenge that I'm having here, and you quoted a piece of a sentence in what I believe is the personal jurisdiction section, but I'm having a little hard time seeing where in the brief you challenge the venue ruling. So can you tell me what the best site is to suggest that I can read your brief to see that you challenge that ruling on appeal?
Sure, Your Honor. That ruling was challenged in the body of the text at the end of our opening brief, where we said because of the district court's finding of improper venue was based solely on its personal jurisdiction holding, its dismissal based on venue does not pass muster. And that's the best I can give you for our opening brief on how we challenged the venue holding of the district court.
That's one sentence on page 54 of your brief.
Correct, Your Honor. In addition to the arguments we made in the reply, in addition to the arguments we made in the supplement or in the briefing on the defendant's motion to summarily dismiss the appeal.
Can I ask you a question about the FSIA issue with regard to the Cultural Heritage Agency? With regard to that, how is the Cultural Heritage Agency any different in this case from the National Museum of World Culture in the case decided in the District Court of the District of Columbia, the Taylor case? That was involving Sweden. Aren't they just exactly the same, and shouldn't the court reach the same ruling with regard to the FSIA as regard to Cultural Heritage Agency in this case?
I don't think so, Your Honor. And to the extent this court believes they're the same exact posture with the same exact facts, the district court in DC just got it wrong. What this court said in Y Oak Tech, quoting Transiero from the DC Circuit, was that the court asks whether the core functions of the foreign entity are predominantly governmental or commercial. Transiero in turn says the question is, quote, whether the obvious functions rather than the uncertain powers. The district court and the defendants erred in looking at the purposes of the ministry's commercial activities, not their function. Defendants, again, lean in, themselves arguing that, quote, although the ministry invests in research, the media, and cultural functions, that investment did not render the ministry's functions commercial, as there is no evidence that the commercial transactions occur for the purpose of individual profit, but rather for a civic and political purpose. But what the Supreme Court set out as the test for figuring out whether something is commercial or governmental under the FSIA says that when, for example, the military purchases boots or even ammunition for soldiers, that still counts as commercial activity for purposes of the act, even though it's done for the purpose of the national defense.
Well,
Counsel, go ahead, Judge.
I'm sorry, my question dealt with the facts of the Taylor case. In the Taylor case, it dealt with a public museum in Sweden which kept some of the remains of a Native American and wouldn't give them back. And in that case, the court held that it was immune under the FSIA as a political subdivision. I mean, doesn't that just squarely fit our facts? I mean, do you know the facts of that case? I mean, why is that case different?
That case is different, Your Honor, because, okay, so it's the public museum there, but the ministry and RCE here, correct? Because the public museums here, no one disputes our agencies and instrumentalities.
Oh, but you know, I mean, look at GARB, Poland's Ministry of Treasury, same deal. It just seems to, well, you stipulate that the ministry and the RCE are to be treated the same for FSIA purposes. And doesn't that stipulation basically do in your entire argument on FSIA?
I don't agree, Your Honor, because the Ministry of the Treasury and GARB, the Ministry of Foreign Affairs and other cases, these are undoubtedly, when it comes to foreign affairs, the national defense, the Air Force, those are easy cases. As the court in DeChapels...
GARB involved expropriated land, right, from Jewish persons. Same issue, right?
Yes, Your Honor, but the question is different. If the question is whether the ministry is a political subdivision or an agency or instrumentality, that question is answered by whether or not the core functions of the ministry are commercial rather than governmental. It wasn't dismissed in the Taylor case on the basis that it said the expropriation exception didn't apply because it wasn't an agency or instrumentality. But that's the exact point that we're arguing here. It's not the acts of whether or not this was expropriated or not. The separate question as to whether the ministry and RCE should be treated as an agency or instrumentality is answered by whether its core functions are principally commercial. And those commercial functions of the ministry and RCE don't have to have anything to do with the art at issue in this case. That is not how the court determines whether or not the ministry and RCE are commercial rather than governmental.
So, Mr. Worcester, I wanted to ask one follow-up on your reference to the Supreme Court, and I think that's the Weltover case. Is that what you're talking about?
Correct, Your Honor.
And I don't know really what to make of this, but I believe that was talking about the term commercial in the commercial activity exception, as opposed to the core function analysis. Now, maybe those are the exact same. Maybe they're not, but I think at least on the surface it was referring to that exception. Has there been authority that says that same rule, that same interpretation of commercial activity applies to the WIOC core function test?
Yes, Your Honor. I believe WIOC itself, but I would further note that in Weltover, what the court was considering was the FSIA's definition of commercial activity. That definition applies throughout the Act, whether it has to do with the core function question presented in WIOC, or whether it has to do with the commercial activity exception provided in 1605. I would like to keep some time for rebuttal, but I just wanted to note that fundamentally, if this court finds that the allegations and even evidence of the specific activity that the defendants directed into the United States using the artworks at issue is insufficient to establish specific personal jurisdiction as to any of my client's claims, it will in effect be holding that Congress could not do what it was trying to do with the FSIA and the many amendments that attempt to provide a U.S. forum to resolve Nazi-era claims over artwork expropriated during World War II. That's because in all of these cases, all such artworks...
You've got some time, counsel, for rebuttal.
Okay, thank you.
Mr. Hartzell?
May it please the court. Sam Hartzell for the Dutch parties. I'm here with my co-counsel, Sarah Erickson-Andre, with whom I will be splitting time today. Now, the district court here dismissed plaintiff's actions on multiple independent grounds. Ms. Andre will be explaining why one of those grounds, venue, presents a clear, straightforward basis for this court to affirm. But venue is far from the only reason why the district court dismissed this case. The district court also dismissed it for lack of standing, for failure to show an exception to the FSIA, and for lack of personal jurisdiction. And as the panel has correctly pointed out, plaintiff has to prevail on at least 3 of the issues in its opening brief in order for this case to be remanded. And not just those 3 issues, but also the 4th issue not listed in the issue statement, venue, which Ms. Andre will be talking about. But I'd like to begin with the FSIA, in particular the discussion about the core function test in Weltover. Judge Quattlebaum, you're exactly right.
Does Kespel recently suggest that the district court in Byrd erred in its conflation of the purpose and function aspects of the WIOC core function test? Hadn't there already been one court that looked at it and said the district court in this case didn't get it right?
Well, the district court there was looking at a different type of entity, which it distinguished in detail. But you're right in the sense that that court did go the other direction. But what I do want to emphasize here is the concession that we've heard about the RCE being a part of, not legally separable from the ministry, means the question before this court now is the Ministry of Education, Culture, and Science of the Netherlands, is that a political subdivision or an agency or instrumentality?
Do you think that stipulation is positive on the FSIA issue?
Yes, it is directly dispositive as to the RCE, because it does. The concession is that it's not legally separate, and legally separate is what the core functions test is doing. But it's also dispositive. It takes, I think, 2 sentences of analysis to determine that a ministry, one of 12 top-level divisions of a sovereign, is a political subdivision and not an agency or instrumentality. We're not aware of any case holding that any entity, whether called a ministry or otherwise, that is a top-level subdivision of a government is an agency or instrumentality. And indeed, the record...
You would agree that you bear the burden on proving the exception? You bear the burden
I don't think that's right, Your Honor, because plaintiff as the party invoking subject matter jurisdiction, I believe, bears the burden of establishing an exception. But regardless, this is something that review...
Court precedent to the contrary. I'm citing Sittervan de Blake versus Republic of Argentina that says, if a plaintiff's allegations and uncontroverted evidence establish that an FSIA exception to immunity applies, the party claiming immunity bears the burden of proving by preponderance of the evidence that the exception does not apply. Okay, and with that in mind, just take that as what it is. If you look at page 750 of the appendix, where I scoured this record looking for what this agency does, what RCE does. And it says, on behalf of the Ministry of Education, Culture, and Science, the agency manages the part of central government's art collection that is not housed in national museums and make it as accessible as possible. So if that's the definition of what the Cultural Heritage Agency does, doesn't it simply fail to be a political subdivision under the core function test?
No, for the threshold reason that plaintiff considered it's inseparable from the ministry, but more directly under the precedent Your Honor cited Taylor, but also circuit court precedent. Courts have consistently held that managing sovereign property is an inherently governmental act under the core function test. Most recently in the Singh case out of the 11th Circuit said that the minister, the entity at issue there, is responsible for, quote, holding and administering Trinidad and Tobago's property. The court went on, these functions are plainly governmental in nature. And where to look in the record, Your Honor, for evidence of what the ministry's responsibilities, what its core functions are, I submit that the best place is the district court's order, page 1819 of the joint appendix. And there, the district court noted, relying on evidence that plaintiffs submitted, that the ministry sets policy and regulates education, culture, and media in the Netherlands.
I'm not so concerned about the ministry as I am the Cultural Heritage Agency. Is it the same thing as the National Asset Management Agency in the Hungarian case, or the State
Your Honor?
Fund, or the State Diamond Fund in the Magnus case?
No, because the purpose of this entity here is not to manage that property for profit. That is, and in DeSheffel, the district court explicitly distinguished the RCE here. Again, I don't want to lose sight of the fact that plaintiff has conceded it's part of the ministry, but it's not just Singh that says management of sovereign property is an inherently governmental act. The Second Circuit in Garb came to the same conclusion. It said it agreed with the district court's analysis, which it quoted as, holding and administering the property of the Polish state is indisputably governmental. So, the point, Your Honor, is that the RCE is not the focal point here. It's a mere department of the ministry. But even if one were to look past plaintiff's concession, not only below, but repeated in his opening brief, that's at opening brief, page 22, note 23. Even if one were to look past that and look at the RCE specifically, that still falls well within the precedent holding that's a governmental function. And
so, counsel, if I could follow up on something before you move on, I'm trying to zero in on how we look at this core functions issue, and there's questions about purpose, there's questions about function, there's also questions about structure, and as I think Wyoke cites Transero, which seems to indicate that structure is at least a factor that can be considered. Do you agree with that?
Yes. So Wyoke does do that when talking about the Iraqi Ministry of Defense, and it cites the Transero discussion saying that when something is bound up in the structure of government, it's no surprise that its core function is governmental. And also, to your question about the Weltover case, yes, the discussion of the commercial activity in that case was a different issue than the core function. And the best place to tell that is Wye Oak itself, because in Wye Oak, the court said that the Ministry of Defense, the ministry at issue there, was a political subdivision. Its core function was waging war and defending the state. But then it went on to find an exception under commercial activity, which is not at issue here. There's been no suggestion that commercial activity has been shown.
But what your colleague would say is that he probably would agree with that as far as it goes, but he still says that even in a different place in the analysis, the exception versus the core function, the term is the term, and they're using the Act's definition. So whether or not you're looking at it in the context of the exception to immunity or whether you're looking at it in the context of the core function, what's your response to his position that it's the same word in the statute with the same definition?
The commercial activity is defined in the statute for the purpose of the FSIA. The core function test is a judicial doctrine that's been adopted to decide whether an entity is legally separate. And I think Wye Oak is instructive on this point because, as I understand plaintiff's argument, it is we have identified some aspects of what the ministry or the RCE does that involve money. But that's invariably true. It's difficult to think of any entity that it wouldn't be.
Sure.
And it's especially true for the Ministry of Defense in Wye Oak. So
right. So let me just stop you because I agree that whether it involves money can't be the end of the thing, or any government entity does that. So that's a fair point. We can talk about that. But I think your point in terms of the analysis that I was getting to earlier is that the commercial, the definition of commercial, let me say it this way, because the core function is a judicially created doctrine, there is no commercial within that doctrine to be interpreted. The only way it could be referring to was within the statutory provision for that commercial activity exception. Is that right?
Yes. And that is the only way to reconcile Wye Oak with the Weltover decision.
Okay. All right. I didn't mean to trick you. You can go ahead. Thank you.
Oh, not at all. Before moving on from the FSIA, I did briefly want to point out that in Wye Oak, that was a breach of contract action to dispose of surplus Iraqi equipment where the plaintiff was obligated to use reasonable commercial efforts to sell that equipment and then would keep 10% of that. So, but the court did not look at, is that particular arrangement, is that governmental or not? It said, what is the overall core functions of the ministry? What are they predominantly? We submit predominantly the ministry's core functions are predominantly governmental. But that's just one of three reasons why the district court dismissed the claims here. Two others are standing and personal jurisdiction. I'd like to address both briefly. So for standing, plaintiff failed to show both injury and redressability. And he failed to show that
Isn't there plainly standing with regard to the plaintiff as third-party beneficiaries of the collection point agreements in this case? They specifically plead third-party beneficiary in count 5 of the complaint. And whether or not they're heirs to the partnership Permacats or not is one issue, but these collection point agreements say that the country was going to hold it pursuant to the determination. I think they say will be held by as custodians pending the determination of the lawful owners thereof. Aren't these folks third-party beneficiaries of the collection point agreement?
So we don't agree that they are, but more to the point for Mr. Berg, he hasn't established injury because he does not connect himself to these paintings. There's the general allegation of I am an heir to my grandfather, but there is no specific allegation of whether Benjamin, the district court recognized this at page 1845, whether Benjamin, plaintiff's grandfather, died with a will, who inherited an interest in Firma Cats on Benjamin's death or Nathan's death, any facts to show that plaintiff's mother inherited an interest in the partnership upon her father's death, when or where plaintiff's mother died, whether plaintiff's mother died with a will, and whether plaintiff inherited any interest in the partnership upon his mother's death. And that was evidence that was missing from the complaint. It wasn't brought forward when we moved to dismiss for lack of standing. And even in the leave to amend, there was no effort to correct that and say, no, all along, here is the evidence, here is the allegation, tracing the interest in this partnership from 1940s Netherlands back to me, the plaintiff. Instead, what plaintiff did is said, I've changed my theory of standing. He wrote, page 1881, that his standing argument is no longer based on inheritance, but on his appointment as a state representative. Now, that's
so what's wrong with that? I mean, let's assume you're right on the heir theory. He alleges he's the PR now. I know the PR came after the suit was filed in terms of its approval, but is that determinative on that issue when the PR was established? Why isn't he entitled to do it, albeit, a little bit late, in the different way?
Because as the Supreme Court reminded us in Carney in 2020, the plaintiff bears the burden of establishing standing as of the time he brought this lawsuit. And this court in the unpublished House decision applied that rule to somebody who had perished 2 days before the lawsuit was filed in his name. There was a later effort to substitute in the personal representative. This court said the personal representative substitution might cure a real party and interest problem, but you must also have standing at the outset. So plaintiff's failure to establish, either at the time or even now, that he had standing requires dismissal for lack of case or controversy. The district court also correctly recognized that redressability is a bar here. Without the Netherlands, there's no way to give relief to plaintiff, and any relief would be an affront to the Dutch state, which claims ownership of this property. And personal jurisdiction is also a independent bar to the claims here. And that's because...
Didn't the Altman case, it's been up and down to the Ninth Circuit a number of times, even the Supreme Court. Doesn't the Altman case stand in contrast to your argument, both with regard to redressability and with regard to the standing of the public museums?
Yes, there is tension there. I would submit that was an early case before further development in the law. And I'd also emphasize, in Altman, there was a clear alleged connection between some of the artworks at issue and the forum. Here, there is never a place where one of the museum's artworks, the 13 artworks that are identified as being possessed by a museum, no specific connection to the forum. The closest plaintiff gets is identifying one artwork that he says is for sale through Getty Images. But if you look at page 1000 of the joint appendix, the evidence, the allegation is the ministry sold that. So that's not sufficient for one of the museums. So, Your Honors, there's multiple independent grounds here for this court to affirm. But the final one, I think, is the cleanest, which is venue, because as Ms. Andre is going to explain, plaintiff did not appeal that. Thank you.
Counsel?
Good afternoon, and may it please the court. My name is Sarah Erickson Andre, and I, along with my colleague Thaddeus Stauber, represent the Dutch Museums. And I would like to speak to you about the district court's determination that venue was not proper in South Carolina. But before addressing the district court's determination, I would like to note that the pending motion for summary affirmance provides an avenue to resolve the appeal without addressing the alternative grounds for dismissal. Here, plaintiff did not challenge the district court's finding that section 1391 F3 does not provide a venue in South Carolina for the agencies or instrumentalities, because general allegations of nationwide solicitation and sales simply do not support a finding that the municipal museums are doing business in the District of South Carolina. Nor did plaintiff challenge the district court's finding that section 1391 F4, which holds that venue is proper in the District of Columbia in a suit against a sovereign or its political subdivisions, cannot apply because the court cannot exercise jurisdiction over a sovereign or a political subdivision where, as here, the claimed property is not located in the United States. The last page of plaintiff's brief acknowledges that the district court's lack of venue finding provides an independent basis for dismissal. noting that even if this court accepts all of plaintiff's other arguments, that leaves one last reason for the district court's dismissal: improper venue. But plaintiff waived any challenge because his opening brief fails to identify any errors in the district court's determination. Notwithstanding the clear waiver and plaintiff's failure even now to assert that the district court's venue determination was an error, plaintiff asserts instead that if he succeeds in his appeal, which would again require
why don't you respond? I mean, he says, no. Like, look on page, 57, 3 lines down in the middle of the paragraph, and I got this sentence that says something to the effect of, because the venue was based on personal jurisdiction, it's unwarranted. Why isn't that sufficient to challenge the district court's independent dismissal on venue for the public museums?
First, I would suggest, Your Honor, that one sentence is not sufficient. Second, I would assert that the statement itself is incorrect. The district courts made an independent determination with respect to venue and found that venue was not proper because there was no evidence, or insufficient evidence rather, that any of the entities were doing business in the District of South Carolina, which is a very separate analysis than personal jurisdiction.
So one on this point, counsel, help me understand what's kind of before us to decide and what's been maybe preserved or not preserved. It seems to me there is a question of whether venue is proper, and we can, look at what the district court said, and we can look at that sentence in the brief that Judge Richardson was just referring to and see whether that's an adequate challenge to that. But then there's a different issue, it seems to me, about if it's proper, if venue is improper, can you dismiss or must you transfer? And I guess my question is, I don't think the plaintiffs have raised that second issue. I'll ask them again about it because I know he mentioned something. I want to make sure I'm clear. But what's your position as to whether the appellant must raise both of the two issues that I've identified within venue?
I think in order to have a constructive discussion about a legal issue, the plaintiff is obligated to raise it in the appeal. I would note, though, aside from the fact that it is our position that these issues are waived, plaintiff's argument regarding transfer of venue is futile. Again, the only subsection of 1391 that applies here, which is F3, with respect to agencies or instrumentalities, directs the court to analyze whether or not the entities are doing business in a particular district. There is no evidence in the record that the public museums or the ministry, to the extent that this court deems it an agency or instrumentality, are doing business in the District of Columbia. I would note that there's one reference, I believe on page 17 of the plaintiff's amended complaint, that asserts that the Central Museum once borrowed an artwork from the National Gallery in Washington, D.C., but that entity is no longer part of the case, and there is no other reference to the District of Columbia in the amended complaint. And certainly, when this court is examining whether under Manning it's appropriate to consider a waived issue, the court is directed to look at the record to determine if the record itself supports the argument. Here, there is nothing in the record to suggest that venue is proper in the District of Columbia. I would also note, if I may, that the plaintiff's brief and discussion of venue in its opposition to our motion for summary affirmance references the Altman and Kassir district court decisions. And there, the district court in the Central District of California made the determination that jurisdiction could sort of be had as to either 1391 F3, which again relates to agencies or instrumentalities, or under F4, which relates to where the sovereign is the defendant, and sort of suggests that there's some that they can be blurred or blended in some fashion. And my response to that is that that is quite old, this case law, and predates the case law we have that recognizes the juridical distinctions between agencies or instrumentalities or sovereigns. But more to the point, in both of those cases, the district courts recognized or determined that they could take jurisdiction over both the agency and the sovereign, and therefore it didn't matter in that court's mind which subsection of the venue provision applied. But here, the sovereign is out. The political subdivisions are out. The only...
Thank you, counsel.
Thank you.
Your time is up. Mr. Woofter?
Thank you, Your Honor. I'll start with the waiver issue because I want to point out that we didn't incorrectly state what the district court got wrong. We said, and I'll quote again, because the district court's finding of improper venue was based solely on its personal jurisdiction holding, its dismissal based on venue does not pass muster. The personal jurisdiction holding of the district court was that nobody had sufficient contacts with South Carolina, and thus F3 of the venue statute did not apply. But as we've said in the opening brief, and is undoubtedly correct, the question for personal jurisdiction purposes are contacts with the United States as a whole, not with South Carolina particularly. So that holding of the district court without doing any further analysis, whether or not constitutional due process requires something different for doing business than the venue provision does as provided in the FSIA are completely different things. And, but more to the point, we actually don't care where this case can be heard in this country. If it's in the District of Columbia, or if it's in Seattle, Washington, because that's where Getty's Images is, if it's in New York, because that's where the Met is, or in Michigan, because of the loans.
But counsel, counsel, that's not how it works, right? You don't, I mean, you have that, you have to show venue is proper. You can't, and sometimes venue, I mean, might not be proper anywhere. I mean, I'm not saying, I'm not prejudging. I'm just saying, I don't think you get to say, well, send me wherever you want me to. I mean, I think the burden is the statute has requirements and you have to meet them. I mean, I know you think you have, but my different point is on this issue, and I won't give you time to the rest of your time, but do you think I mean, I understand your argument about the sentence where you challenge venue is a sufficient challenge to the court's dismissal, but it seems to me there's another issue, which is the court could be right that you didn't have venue, but arguably should have transferred the case in the interest of justice. And you don't raise that issue, do you?
No, that is absolutely something that we raise, and that is the point of the footnote.
Where did you raise that?
So we didn't raise it below, Your Honor, because as we noted, the district court never had occasion to consider whether to transfer, because as my counsel on the other side just acknowledged, it would have been futile to do so. The district court had already found that we lacked standing. And to go to standing for just a moment, House doesn't apply. We didn't bring this case in a dead person's name. We brought it in Berg's name. Berg always had an injury in fact from the outset of this case as the heir. Whether or not we pleaded that sufficiently doesn't matter now, because the fact that we were injured had been existed from the outset, and we could now factually establish that. And in fact, this court did so in Jeffy Spindler Covey Genesco, 747 F. 2nd, 253, on appeal at oral argument, allowed a defect in the jurisdictional pleading to be amended pursuant to 28 U.S.C. 1653. As for redressability, there is simply no legitimate basis to affirm the district court's musings that even just the public museums could not fully redress any of my client's claims, at least as to the artworks they possess, control, and display. The district court based that on a holding that they might ignore a judgment, but that's not the correct inquiry. Judgments are had all the time against defendants who ignore or otherwise can't satisfy them. That has nothing to do with redressability. And finally, I just want to point a couple of allegations out with my remaining time. Defendant Museum Prisenhoff loaned NK2650 the Grand Rapids Museum of Art. Dordricks sold a license for an image of 1695 to Getty Images. Dordricks and Lockenhall also used two different pieces of art to promote and sell tickets into the United States. The Ministry and RCE loaned different pieces of art to the Cleveland Museum of Art for exhibition and to the Met for exhibition. In all of these cases, all such artworks were taken in violation of international law abroad, such that much of the relevant conduct occurred elsewhere decades ago. And it is difficult to conceive of a case where a plaintiff can reasonably expect to show more at this stage than we have, specifically that the defendants profited from activity they purposefully directed in the United States using the artworks that were expropriated by Nazis. Thank you, Your Honors.
Thank you, counsel. We would obviously love to be able to come down and thank you in person and shake your hand, but the times prevent us from doing so. But please know that we appreciate your advocacy and we'll take the case under advisement. We'll go to the next case, which is 21-1300 Nadindala versus WakeMed. Do we have Mr. Taylor?
Thank you. May it please the court. My name is John Taylor, and I represent Dr. Haritha Nadindala. And I'd like to reserve 5 minutes of my time for rebuttal, please. I'd also like to advise the court that we are resting on our briefs on the issue of the district court's decision to dismiss plaintiff's claims for negligence and breach of the implied covenant of good faith and fair dealing. And I'll be addressing the other arguments in my time today. Your Honors, there is no question here that plaintiff's complaint pled but for causation as it relates to the Section 1981 discrimination claim. It is undisputed that we did that at paragraph 124 of our complaint. The only dispute is whether plaintiff's allegations, all of which must be taken as true at a 12B motion, comply with the pleading requirements of racial discrimination claim under Section 1981. And under not only longstanding case law from this circuit, Your Honors, but also under the Comcast decision that is at issue and mentioned in the briefs numerous times by the United States Supreme Court, the plaintiff clearly met this pleading requirement. And for this reason—
Question, Mr. Taylor, and I
Yes,
read
Your Honor.
124 of your complaint, and it is a conclusory allegation. It says, but for plaintiff's race, defendant's wrongful conduct of plaintiff alleged herein would not have occurred. Okay, that's all there is. Where are the facts alleged in this complaint that support the alleged racial discrimination? I agree with you. You use the words but for cause. I mean, you do that. But where are the facts that support the conclusory allegation of but for causation?
Yes, Your Honor. And throughout our complaint, we set out how our client was a qualified physician, qualified to be entitled to hospital privileges at the hospital, and that she was subjected to a extremely bad faith and unfair process at the hospital that we set out in detail, and that she's a member of a racial minority group as a physician of Indian origin. That's in paragraph 117. That prior to forcing Dr. Nadindala out of her clinical privileges, the defendant hospital had similarly forced out other physicians of Indian origin and removed their clinical privileges unjustifiably as well. That's paragraph 89. And despite the wrongful denial of plaintiff's hospital privileges, the defendant has continued to issue and grant privileges to white physicians. That's at paragraph 136. Minority physicians were scrutinized more harshly at defendant's hospital than Caucasian physicians. That's paragraph 134. And from 2017 until the present date, the hospital has treated our client, who is an Indian physician, differently than white physicians who are similarly situated. That's page 127. And then, as I said,
counsel, let me interrupt you and just follow up on Judge Urbanski's question. I mean, even what you're just saying and what you're talking about just now, I mean, yeah, it doesn't. I mean, it doesn't. I mean, it is fair. You allege your clients is a minority, and you allege generally that that the defendants have treated white doctors differently, but it doesn't. It doesn't do. I didn't see the facts, and it looks like the sections you're talking about, paragraphs 88 through 104, and I didn't see anything in there that give any amount of detail that would allow us to say, if what you say is true, that in fact constitutes discrimination. I mean, it's more like the conclusions, and so sure, if the conclusions are correct, you would win. But maybe I'm wrong. But as I read, Iqbal and Twombly, you got to do more than that. I mean, if you have a case that says the type of allegations that you've pled are enough, if you would give me that case, because right now I'm concerned that what you've pled doesn't rise to what Iqbal and Twombly require.
Well, Your Honor, I believe there is case law, and we cited it in our brief, that treating...
Well, what's your most, I mean, I don't mean to, I'm sorry to ask you a question and I interrupted. I apologize on that. But
okay.
If you would give me your best one or two cases for pleadings, and then I'll let you answer. I really didn't mean to interrupt you after asking a question.
That's okay, Your Honor. I believe the White-Phillips case, I'm looking for that in our brief, was decided after the Comcast opinion that holds, I'm trying to find the page of our brief, but that holds having a person who is of a racial minority treated differently than a person who is a Caucasian or a white person. Just alleging that is enough, along with the facts of what happened. We also referenced the Woods v. City of Greensboro case about a minority-owned business and a contractual breach claim treating white business different than a minority-owned business. And so I think, Your Honor, it's hard to get inside the mind of a group of people. And this is a complex, multi-person group. This is a hospital where a lot of different actors are involved. It's not a black and white thing. It's a lot of people involved in this decision for a lot of reasons that work together. And there are more than one but-for causes for this, where you have racial animus and discrimination that had occurred in the past, like we alleged, to other physicians, and occurred again here, where white physicians are treated differently and better than Indian physicians. But also, you had direct competitors of our client who are other OBGYN physicians in the area who wanted to force our client out of business. And so those two things working together for both but-for causation.
Right, but isn't the other group, aren't the allegations with regard to them inconsistent with the claims of race discrimination in this case?
Well, Your Honor, I don't think it's inconsistent, respectfully, because the law is clear, even under the Comcast decision and the other decisions in this circuit, both before and after Comcast, that you only need to have a particular discriminatory conduct be a but-for cause, not the
but isn't the other group here, aren't those also folks who may have the same national origin claim that your client does?
Well, it is two things working at the same time, Your Honor.
But Iqbal says it's got to be plausible. And if you're saying there's another group that is of the same national origin or race classification as your client, and that they got favored in favor of themselves, how can you argue that therefore it's race discrimination as opposed to just a state law claim of favoring a competing group?
Well, Your Honor, I wouldn't characterize it in exactly that way. I think that the competing practice that we're talking about, one of many physicians in this group happens to be of Indian origin. But that doesn't mean that the hospital is saying, we choose this one group of Indian physicians and we're going to discriminate against you, Dr. Nadenla. They were discriminating against her based on her Indian origin. And then at the same time, there was anti-competitive motivations happening. Both of those two things are but-for causes that resulted in this harm, in this objectively unfair process that occurred.
Paragraph 66. In addition, on information and belief, defendant WakeMed considered the opinion of another of Dr. Nadendala's direct competitors, Dr. Vijay Sheshadradi, regarding one of the patient events at issue. So how could crediting and favoring Dr. Vijay Sheshadradi be evidence of race discrimination against Dr. Nadendala?
It's, Your Honor, it's for the reason I just described, that there was a racial discriminatory intent at issue. And then they also favored a competitor group of Dr. Nadendla's here in the Cary, North Carolina Triangle area. One of those physicians happens to also be of Indian origin. That's Dr. Sheshadri, but he's not the only physician in that group. Doesn't
that suggest that your complaint is not of race discrimination is not plausible under Iqbal and Twombly?
Your Honor, I don't believe so. And because the plausibility threshold is a low bar. We just have to plead enough facts that there is a plausible claim for relief. And we have pled that other physicians were discriminated against by WakeMed Hospital. Other physicians were denied privileges based on their race, that white physicians were treated better and differently than minority physicians. And then we looked at the actual conduct of what happened, Your Honors, where you have, they did not even call or consider any of the medical records for any of the patient care issues when they're denying our clients.
Sure. Let me pick up with that, and that may be. I mean, I understand those facts, and I'm not commenting one way or the other. And I think your breach of contract claim, the court denied the motion as to that. But it seemed, and that's where it seems like at least one place that would go. Let me ask a question, and I may be going a little bit behind what you wanted to do, because you wanted to rest on your briefs on an issue. But if you don't mind, I'm going to ask you about it.
Sure.
Assume I disagree with you that on your 1981 claim, but agree with you that you've pled a plausible breach of implied covenant of good faith and fair dealing claim. What should I do?
Your Honor, I would say in that situation, you should still issue an order reversing the decision on the breach of implied covenant and good faith and fair dealing. Of course, we think that the 1981 claim was proper too. It should be reversed, and that's the main claim we're talking about here. But yes, we think that the law is clear. We set it out in our brief that that's an independent cause of action for breach of implied covenant of good faith and fair dealing. It's not just, part and parcel of the breach of contract claim. So that was error as well. As to the procedure of what would happen if it was remanded on only the state law claim, I'm not sure exactly how that would all work out. But yes, I think that the court should, if there's an error and we appealed it, issue an order and a decision stating that the lower court erred in that ruling. Your Honors, I do want to continue with some of the points that I'd like to make, Your Honors. And it's clear that we pled but for causation. I've explained why we've pled plausible facts that meet the, even under the Comcast opinion. And the way that we stated, we did use the words. And I just want to point out, Your Honors, that the defense's argument that there can only be one but-for cause of a wrong, to the extent that Your Honors are considering that type of argument should be rejected, that would create an absurd result. First of all, the Comcast court itself said that you can have multiple but-for causes using the word a. They say, quote, a plaintiff bears the burden of showing that race was a but-for cause of its injury. And then subsequent courts after Comcast have also used a but-for cause rather than the but-for cause, saying that there could be more than one. And including the United States Supreme Court case in Bostock v. Clayton County that said events may have more than one but-for cause. And if that were not to be the law, Your Honors, that would create an absurd result, because then the defendants, if there was a defendant who committed more than one actionable wrong that results in an injury to a plaintiff, they would escape liability from that just because the plaintiff now has more than one but-for cause of their injury. The defendant would ultimately be awarded for committing more than one form of actionable wrong that caused the injury. And the law then would not protect a victim who had been wronged by a defendant who had been, but it would only protect a victim when there was a defendant whose conduct was only one but-for cause of the harm, rather than even more egregious conduct by a defendant that had committed more than one but-for cause. And this comes out in a lot of different contexts, Your Honor. I know I'm into my rebuttal time, but like in the employment context where a employer may fire an employee based on both racial discrimination and retaliation for filing an EEOC complaint or something like that, Your Honor. So there's other contexts as well. I'll save the rest of my time for rebuttal. I do have other points to make, including on the motion for reconsideration, which separately amounts to error by the district court, that I'll address that in my final 5 minutes. Thank you, Your Honor.
Thank you, Mr. Taylor. Ms. Hittrick?
Yes, thank you. Good afternoon, Your Honors, and may it please the court. My name is Elizabeth Hedrick, and I am here on behalf of the appellee WakeMed in this case. I'm happy to address any questions you have, but otherwise, I want to start briefly by addressing that last point that Mr. Taylor just raised, which is the propriety of the court's granting of the motion to reconsider. And I think that one's fairly easily disposed of. The trial court has discretion to revisit any interlocutory order at any time before final judgment. That's both inherent and that is granted by the rules of civil procedure. And we simply don't see that it can be an abuse of discretion to reconsider something so that you apply the right standard and get to the right result. And that's what happened here. The court itself said in its order that it had not applied the right standard to the motion to dismiss and that it could not ignore that standard. And the only case that either party has cited to the court where that addresses whether it's error to grant a motion for reconsideration is the Schrader versus CSX transportation case. That's from the Second Circuit. And there the court, it's a very similar situation. The party that had moved originally to dismiss the claim came back with some additional authority and asked the court to reconsider its order. The court reconsidered its order and granted the motion to dismiss. And the Second Circuit said, we can't say that's enough to find an abuse of discretion. And so I don't think that
that's true in this case, where the suggestion is that the Comcast case didn't really change the law, that it was simply a further statement of the law that there can be, following on Bostock, got to be but-for, but there can be multiple but-for causes. I mean, Comcast really, in this case, even the district court did the right thing by issuing another opinion addressing Comcast.
Yes, Your Honor. And I think if you look at the Schrader case, in that case, the court, it wasn't even a different standard or a question of whether the court had applied the right standard. They had looked at case law from two circuits and hadn't looked at other cases from similar circuits, and the movement came back and said, hey, there's this other thing, we think you got this wrong. Every circuit that's looked at this says you've gotten it wrong. And the trial court looked at it and said, okay, I'm going to reconsider my order. I think that here, whether Comcast clarified the standard or announced a new standard, maybe that's questionable. Although I will say that it made a big impression in the bar. If you look at the articles that came out, everyone saw that as something new. And I think you won't really see a shift in the way that the courts had analyzed it since. And most importantly, I think you have the trial court here saying, that's not the standard I applied. I didn't look to see if she had plausibly alleged race as a but-for cause, and that's what I need to do. I got to get it right. So I think that was plainly within his discretion. I think any court that's looked at that similar issue has come to that conclusion. But unless there are any other questions on that, I would like to move to the question of whether the plaintiff pled race as a but-for cause. And I think it's easy to get turned a little bit sideways here. I agree with some of the implication of some of the questions that were posed earlier, that I think it's questionable whether she plausibly pled that there was any racial discrimination here at all. But she did have some generalized allegations with some vague facts to back that up. But the district court concluded that she had plausibly pled racial discrimination. What the district court decided she hadn't plausibly pled was that the racial discrimination was a but-for cause of her removal from the medical staff. And I think implicit in his initial order was that she had alleged it was a motivating factor, but as we know from Comcast, a motivating factor is not enough. It has to be a but-for cause. And as Justice Gorsuch pointed out in the Bostock case, the question for but-for cause is, let's look at the complaint, let's take all the allegations and start removing things one by one. And so here, if you remove race from the equation, can you conclude from the face of the complaint that the result in this case would have been different? That's the test that Justice Gorsuch announced. And I think if you look at this complaint, that's simply not a plausible inference. As your honors pointed out in your questions to plaintiff's counsel, there's only a single allegation that race was a but-for cause of Dr. Nadendala's removal from the medical staff. And that is the exact kind of conclusory allegation that Twombly and Iqbal tell us we ignore that when we're assessing plausibility. There's only a single other allegation as to the cause or the but-for cause of her removal from the medical staff. And that is paragraph 81. And there, Dr. Nadendala alleges that the decision was driven by the improper financial motives of at least two physicians, Dr. Grana and Dr. Shashadri, and their practice, because as she alleges, they stood to gain financially by her removal from the market. That right there is a factual allegation supported by detail that says what drove the decision to remove her from the medical staff. It wasn't race, it was the improper financial motives. Now, I think there's questions as to whether Dr. Nadendala Mr. Taylor talked you through some of the allegations about the fairness of the process and those sorts of things. And I think, as I understood the argument from the briefing, that shows that the proffered basis for her removal from the medical staff was pretext. In certain cases, maybe she's raised enough here to raise an inference of pretext, a plausible inference of pretext. But I think the facts that she has alleged don't plausibly lead to the inference that the proffered basis was pretext for discrimination, or that the discrimination was a but-for cause of her removal from the medical staff. I do think because of the facts that she alleged, it's not plausible to infer that the proper basis was purely pretextual, at the very least. As she pled that in paragraph 24, the proffered basis was that there were clinical concerns about her practice or the care that she was providing at the hospital. And in paragraph 27, she alleges that each of the parties litigated those alleged clinical concerns throughout the MEC process. In paragraph 36, she says that the MEC considered a 3-page summary of all of her peer-reviewed case reports that addressed her clinical care. And most importantly, she alleges that the evidence before the hearing panel in her fair hearing at Wake Med showed that there was conflicting information regarding her patient cases between the nurses and Dr. Nadendla. She doesn't allege that the nurses acted with any racial animus, and it's just simply not plausible to conclude that well-founded concerns about her clinical care did not play some part in the decision that would give rise to an inference that improper considerations caused the decision. But even if pretext is a plausible inference here, the question becomes, what was it pretext for? And that's where I think if you look at the allegations as a whole, look at her complaint as a whole, the only plausible inference is that if it was pretext for those improper financial motives of her competitors. And how do we know that? Again, we know that because that's what she alleged. She alleged that is what drove the decision here. And we apply Justice Gorsuch's test and look at the facts that alleged. She says Dr. Grana and Dr. Shashadri are her direct competitors. She alleges that they manipulated the process that resulted in the decision. She alleges that Dr. Grana was the chair of the OBGYN department and that she raised serious concerns about Dr. Nadendla's care in the review process, something that Dr. Nadendla says was very unusual for a department chair to do. She says Dr. Shashadri had provided an opinion regarding Dr. Nadendla's handling of a patient event that was considered as part of her application review. And she says both Drs. Grana and Dr. Shashadri stood to gain financially by removing her from the medical staff and from the market. She also goes into a lot of detail about a business dispute that she was allegedly having with Dr. Grana and Dr. Shashadri. Apparently the practices had similar names, and Dr. Grana and Dr. Shashadri had asked Dr. Nadendla to change the name of her practice, had offered her money to do that, and she'd refused them. And she says that this refusal—
Should the court in this case have granted leave to amend? Should the district court have, rather than just dismiss the case, should the district court have said, it doesn't look like they have sufficiently pled 1981 on its face. We're going to grant, rather than dismiss the case, grant leave to amend. Shouldn't the district court have done that in this case, Ms. Hedrick?
Well, Your Honor, I think there's a couple reasons that didn't happen. And one is, I think I was a little surprised that the plaintiff never asked for leave to amend the complaint. But secondly, I think the court saw there was no point to do that. If you look at the allegations, I think Dr. Nadendla made a litigation strategy call. She looked at what the facts that she had to work with, and she thought, wow, I've got a lot more facts to work with on this improper financial motives. I don't have a whole lot I can say on racial discrimination. And I think there's a reason for that. We had a 12B1 motion pending on this very issue, which was that this federal claim was her hook to get into federal court because she wanted to avoid some unfavorable state law that would hamper her discovery. But I don't think she could cure this, Your Honor, because if she alleged it, she'd have to drop her other allegations in order to establish race as a but-for cause.
I don't think we can consider all that stuff that you have in your brief about the first state law. There was a state court complaint that was sent to you, and then you raised an issue about whether or not there was a privilege based on the staff privileging decisions and evidentiary privilege. Because this was dismissed on 12B6, I don't think we can consider any of that, right?
Well, Your Honor, I think it is part of the record. It was not objected to for inclusion in the record. I do think that it probably isn't relevant to the question of whether or not she plausibly pled race as a but-for cause. I think that's fair. I will say, though, that it certainly explains why the Twombly and Iqbal plausibility standards are there. I mean, this is exactly the kind of thing that's required, that standard was adopted for. It's not enough to just give some very general allegations of discrimination.
I understand that, but the problem is the case wasn't dismissed on 12B1, it was dismissed on 12B6.
No, Your Honor, and I don't think you need those facts. I honestly, I don't think you need them to decide this case. I think the way she pled her complaint is what sinks her case. She pled a but-for cause, for sure, but that was the improper financial motives. And Your Honor, that doesn't leave her without a remedy for what she's complaining of. She still has her state law claims. Those claims are pending in state court right now. But she can't therefore shoehorn a discrimination claim because she can't allege that the race was a but-for cause. She just doesn't have the facts to back that up.
So counsel, if I could interject, you raised state law claims. One of the issues on appeal is the dismissal with prejudice of two of the state law claims, one negligence and one breach of implied covenant of good faith and fair dealing. That was a little hard for me to get my arms around what the law is. I mean, we have some district court cases that say a couple of different, seems to me, different things. We have some, state law cases, not from necessarily the highest courts, but seem to say something else. But I'm having trouble with the concept that someone couldn't plead facts and say, I think those constitute a breach of the express provisions of a contract. And alternatively say, and the answer may be no, that they're not clear enough that they're a violation of the express provisions. But if that's the case, that they couldn't, at least plausibly plead an implied covenant of good faith, fair dealing. And so I didn't, it seems to me that, that's what he pled, and the basis for the dismissal was that they're the same, which really seems to me they could be alternatives, and I'm not sure what's wrong with that. Help me understand how that was correct.
Sure. So I think, Your Honor, that that North Carolina law is clear that you can sometimes have claims for both. But there has to be, it would be separate and distinct from the contract claim, but the allegations would have to be different. And that's not what the district court concluded here. And I think if you look at the way she pled it, it was rising and falling on the same allegations. And I think if you look at the state court cases at that point, that claim just becomes subsumed into the breach of contract claim. And it's an element of that claim, essentially. If she can prove that, she'll prevail on her breach of contract claim, is how the court
that may be right. And I got that too. And it sounded like, to an extent I could understand, that you could still somehow plead that, which makes this, it seems to me, a little bit academic, perhaps. I'm not sure it's correct, but anyway, I appreciate your answer. I understand what you're saying.
Okay. Going back to the question of whether she plausibly pled racism but for cause, I think if we look at the allegations, we've talked through all of those allegations about the improper financial motives, and then she does include some allegations about race. I mean, she says she is an Indian physician and that at some unidentified time in the past, WakeMed forced out at least one unnamed Indian physician.
And why isn't that enough? Why isn't it enough on a pleading standard under Iqbal and Twombly? Why aren't those facts sufficient?
Well, I think, Your Honor, if you look at some of the courts that some of the cases that this circuit has decided, you see, for example, the Painters Mill Grill case that we cited to you, the court concluded that similar allegations that don't give you details about who was involved, when this happened, it just doesn't make it plausible enough to infer discrimination. Now, that's one question, but the second question, and that's the one that really is before the court, because I think the district court concluded that she plausibly pled discrimination. What they concluded she didn't plausibly plead was that the discrimination was a but-for cause. And so if you look at it from that perspective, you have all of these weighty allegations about the improper financial motives. They're very detailed. a lot of information there. And you just don't have the same thing with the race motives, or the race allegations.
Counsel, do you agree that as to the put aside for right now the but-for causation, do you agree that there's been adequate pleading under Iqbal and Twombly of racial discrimination?
So we don't concede that, Your Honor. I mean, that was our initial argument at the outset of this case. The district court disagreed with us. I don't think, I think that under a lot of cases, under similar cases, and again, I'll refer you to the Painter's Mill Grill case that this circuit decided, this circuit said those kinds of allegations aren't enough. But the district court didn't agree with us here, so that's not really the issue that we're arguing about on appeal. But no, okay. I don't think we concede that. But I do think there is a difference between plausibly pleading discrimination, which is enough to satisfy the motivating factor test, and plausibly pleading that the discrimination was a but-for cause, which you have to do to satisfy Section 1981 standards. And that's why the district court said, I got to look at this again, because he had looked at it under the motivating factor test and decided, well, I think, maybe it's enough, maybe it's not, but I think it's enough to go forward at this point. And the problem being, once he realized that the standard was, has she plausibly pled that the race was a but-for cause, the district court concluded that it couldn't reach that conclusion. She had not. It was not plausible. And I think that's because you see all these allegations on the one hand. Particularly, again, she's the one herself who alleged that the improper financial motives drove this decision. This is what drove the train. And then she has these generalized allegations of racial discrimination, but there's just not enough meat to those allegations to conclude that they had a similar driving effect. Because, again, the only allegation you get that it had any impact on the end result that came out of this decision was that very conclusory race was a but-for race, this decision wouldn't have happened. And so she simply she didn't give enough information for the court to conclude it could plausibly infer that race caused the decision. I do want to touch very briefly on the question of whether you can have more than one but-for cause. I don't think that matters here. I have a hard time envisioning how you can under the Gorsuch test, but it really doesn't matter here because the district court applied that standard. The district court said, I'm looking at whether race was pled as a but-for cause, and you can have more than one, and race wasn't pled as a but-for cause here. And unless you have any other questions, I see my time is up, so thank you.
Thank you, counsel. Mr. Taylor, you got a few minutes.
Thank you, Your Honor. And just want to point out that proving discrimination is rarely ever direct. It's subtle. And it's almost always proven by circumstantial evidence when taken together that a jury could find that racial intent was what motivated the action. And one of the cases that we cited in our brief that I highlighted but didn't know the page for, I want to point out to the court now, Your Honor, it's on page 28, the Wright Phillips versus United Airlines, Inc. case in that last paragraph. It says that allegations that, quote, the refusal to perform a contract was motivated by race, i.e. that a person of another race with a similar complaint would have been treated differently, close quote, had been held to satisfy the but-for causation standard following the Supreme Court's decision in Comcast. That's a recent decision. And there's been even more decisions since Comcast has come down. A lot of different cases have cited it, Your Honor. This was as of our brief back in April where we cited that. But I want to, with my remaining time, go to the motion for reconsideration because this was a separate error by the trial court that requires reversal. And the procedural history, Your Honors, is set out in our brief in detail. We filed this complaint back in November 2018. It wasn't until October 29th, 2020 that the district court ruled on defendant's initial motion to dismiss. In that time, no discovery was allowed to be conducted because the court granted the defendant's motion to block discovery while the motion to dismiss was pending, and it was pending and fully briefed for 22 months. And then when the district court finally ruled on the motion, it denied defendant's motion to dismiss. It got it right the first time. It said that we did plausibly believe discrimination. And under the Iqbal and Twombly pleading standard, based on the allegations in our complaint, that was plausible. And we didn't change any, I mean, in light of all the allegations that you've heard all about with the anti-competitive motivations as well. And then we submit it was a shocking change of course, Your Honors, to immediately after that on defendant's motion for reconsideration, reverse itself without adequate grounds. And the law is well settled. We submit that a motion for reconsideration is not a vehicle to identify facts or legal arguments that could have been made, but were not raised at the time the relevant motion was made.
There's not even any provision in the rules for a motion for reconsideration. I mean, the federal rules of civil procedure don't call for it.
That's correct.
I mean, people do it all the time, but it's not called. It's not in the rules.
That's correct, Your Honor. I agree with you completely. And in our case, under the local rules of the Eastern District of North Carolina, there is a provision that requires subsequently decided authority, like what the Comcast case was in this case, to be submitted. And if this made the type of waves across the bar and was published in every article like defense counsel referenced in her comments, why didn't they submit that as subsequently decided authority when it was out for over 7 months before the court issued this motion to dismiss?
This is the hold that in the Fourth Circuit, folks shouldn't be allowed to file motions to reconsider, because I tell you, there's some district judges that would like that.
Yes, Your Honor, I agree completely, because the rules against motions to reconsider are very important, because otherwise you would just have an endless relitigation of the same issue and getting additional bites at the apple over and over again. And for our case, we had to wait 22 months for that apple to be bitten the first time, you know, and it was very unfair to us.
So, counsel, let me follow up on that, and I appreciate the timing issue you just mentioned. But I mean, whether it's framed as a motion to reconsider or order granting or denying a motion to reconsider, I mean, if a district court judge just determines that it issued an order that, upon further reflection, you know, it is not the way it feels the law should be, are you saying the district court doesn't have the ability to correct itself?
The district court may have that ability, but that's not what happened here, Your Honor. The district court said that, in its opinion, the Comcast case amounted to new law that would, you know, fit into this standard of when you can do a motion for reconsideration. Right. And as we stated in our briefs, it didn't. It only clarified the law that already existed in the Fourth Circuit that already applied the but-for causation standard for 1981 cases and other discrimination cases. That was already the law, Your Honor, and we pled it right the first time. Well, I thank you all very much for your time.
Thank you, counsel. Obviously, we'd love to come down and greet you and thank you in person for your argument, but we can't do that in this current time. But no, we appreciate your advocacy, and we'll take the case under advisement. We'll move to the next case unless my colleagues need a break.
My name is Jim McCowan, and I'm appearing today on behalf of the plaintiff appellant Jeffrey Stanton, administrator of the estate of his late father, Spencer Crumbly. As the court knows, this case involves a fatal shooting which occurred on the Crumbly property on December 17, 2017. There are 4 issues I would like to take up with the court today. First, whether there is a material issue of fact as to whether the officers acted reasonably. Second, whether there is an issue as to whether or not there was clearly established law that was violated. Third, whether the complaint pleads wrongful death claims based on negligence and battery. And fourth, whether the defense of qualified immunity should be abolished or modified in some way. While I'm talking about the issues, I would like to tell the court that we are withdrawing our bystander liability claim against Officer Cornelius. So I will not be addressing that issue today. Turning to the issue of
Your only claim then is against Officer Elliott, Trooper Elliott?
Pardon?
Your only remaining claim is against Trooper Elliott?
That's correct, Your Honor.
Okay, thank you.
All right. As to whether or not they acted reasonably, the court, well, excuse me, the jury.
I'm sorry to interrupt you before you do this, but it's going to help me sort of maybe understand the argument a little bit better. I had a little hard time following exactly what looked like was happening based on the record. Can you describe for me in as best detail you can, sort of when they get to the house and you know, is the house on the officer's left-hand side or right-hand side when he goes around the corner?
When you get to the property, there are two structures there. There's the main building, the cabin on the left, and the A-frame on the right. And prior to the shooting, Mr. Crumbley had been running from the cabin on the left toward the A-frame on the right. Now he goes around the corner of the A-frame.
When he goes around the corner, what side of his body is closest to the A-frame? Is that his left
side? His
left shoulder.
Yes.
Okay. So when he goes around, is his left shoulder. When the officer goes around the A-frame, is it, I assume, also the obvious that is also the officer's left shoulder that's closest to the A-frame?
Correct.
And then
are they making a left turn?
Yes. Yes.
Okay. I'm sorry, Judge Richardson. I just
no, please. This is I want to make sure I'm following. And then can you describe for me, because the photos don't help me a ton. So I then have the A-frame is on my left. I'm the officer. The A-frame is on my left. There's a couch. Is the couch against the A-frame such that the longest side of the couch is against the A-frame, or is the short side of the couch against the A-frame?
The officer is looking straight ahead at the end of the couch, and the long side of the couch is up against the A-frame.
Okay, and that's on his left, off of his left hand.
When he shoots, he is facing the couch. That's straight ahead.
Okay, that's helpful just to have it in my own mind. Go ahead. You can go ahead. Thank you.
The jury, if it gets to this, will have to determine where the first shot fell in the second shot. There are two shots. There's one to the right hand and there's one to the back. And Trooper Elliott, when he was deposed, could not remember or say which shot was first. Now, there are a number of possible scenarios here. One is that the first shot was to the hand, which is a very serious injury which could have incapacitated Mr. Crumbley. There's a possibility that he was running straight ahead, posing no threat to anyone, and that's why he got shot in the back.
Yeah, counsel, is the shot to the hand, is it in the back of the hand? Is the entry wound into the back of the hand, exit wound out of the face of the hand?
As I recall, it enters the back and emerges from the palm. But I think the pictures show that, Your Honor.
It is. The autopsy report says the hand wound is back to front, left to right, and upwards. That's what the autopsy report says.
Yes. Thank you, Your Honor. That's the medical examiner's report.
So he's not standing in front of him with his hands outraised, with his palms in front of him. He shot in the back of the hand, is what Judge Richardson's asking.
Well, it's hard to tell what his hands were like when he was originally shot because we don't know which shot was first, whether it was the hand or the back. The first shot might have spun him around. So it may be that he had his hands like this, or it may be that he didn't. That's something that the jury would have to determine. And then another possibility that the jury might find based on the facts and reasonable inferences is that Mr. Crumbley was rooting around in the couch, and then all of a sudden he turned around and faced the officer and got shot. And of course, that's what the defendant is arguing. And another possibility is that he was raising his hands.
Mr. McCown, my problem with this case is you're talking about possibilities.
Yes.
And aren't you simply asking the jury to speculate what happened? And on this record, where is the evidence? Where is the evidence that the officer acted in a way that violated your client's civil rights? Because aren't you just simply asking the jury to speculate?
Your Honor, if the jury could come to different conclusions, a reasonable jury based on the facts, reasonable inferences, there's a genuine issue of material fact. I think one of the facts that was very important, and I don't think that the lower court addressed it in the sense in which we argued it, is that there was no gun. The lower court correctly understood that she could have a reasonable but mistaken belief that someone had a gun, but that wasn't really our issue. The issue was whether or not the absence or presence of a weapon made it more or less likely that someone engaged in the furtive conduct that was alleged, namely reaching into the couch and rooting around. And there was other circumstantial evidence. There were no cushions on the couch.
So counsel, I guess let me ask, because I'm struggling a little bit, because I thought what you were going to say was this isn't speculating. In response to Judge Urbanski's question, I'm not asking anybody to speculate at all, because the bullet went in his back.
Yes.
Right. That fact, whatever testimony is, like, the man was shot in the back, and that, so that's point one, and that's can't be controverted, that he was in fact shot in the back. And two is that if you shoot somebody in the back, that you cannot shoot somebody moving away from you in the back, right? That would be clearly established law.
That's correct.
And so those facts alone would be sufficient for you to prevail.
Yes, Your Honor.
And then the speculation is not in that, which is your story, as I take it, but is instead your colleague, because what your colleague, the officer is asking us to speculate, or asking a jury to speculate, is that he got shot in the back, not in the way we would naturally think someone gets shot in the back, but instead by virtue of some sort of spinning movement that's, at least as described by the officer, more than a little hard to follow.
That's correct, Your Honor. And the officer's argument will be that the gentleman was turning around to face him, and he continued to spin after he was shot. Now, why he would continue to turn after he was facing the officer is not clear. Another point that shows up in the medical examiner's report is that the trajectory of the bullet that went in the back was in a downward trajectory, not straight ahead as you might expect if he was standing up and the officer was shooting straight ahead. So there's certainly a basis for the jury to find.
That would make sense if he's rooting around in the couch, right? Wouldn't a standing up officer be above someone who's rooting around in the couch looking for a gun?
Well, he wouldn't have been turned in the right direction then.
Right, because the officer says he turns and faces him before he shoots. Right? He doesn't shoot him while he's rooting around.
No, he does not. He is standing facing him, raising his hand. So these are all.
It's on page 89 of the record. He says, now, when you say he was turning, his deposition, when you say he was turning, was this part of the turn that he was doing when he was turning from the couch? Answer, turning towards me. Question, towards you? Answer, yes. So he doesn't say whether he's standing up or not. He says he was turning. And Judge Richardson, I may have missed it if he said that he was standing up, but he was turning towards him. That's in the deposition testimony.
Yes, Your Honor.
But I agree with you, Mr. McCown. How is this in the downward trajectory? That's what the medical examiner's report says, Your Honor. Did you have any expert testimony with regard that you presented with regard to an affidavit or something to discuss how this couldn't have happened as the officer described? Did you have
No,
any
Your Honor.
expert testimony?
No. So,
Counsel, just to follow up, excuse me, Counsel, to follow up on that point. So tell me if this is a fair characterization of the evidence. We have physical evidence of the injuries to your client's father that, you know, are a shot in the back and a shot in the back of the hand. And if that's all you had, you could, you know, talk about a bunch of different ways I guess that could happen. And we have the testimony of a, of a witness who describes events in a way, and, you know, we can decide, I guess, whether that description, you know, is reasonable or unreasonable. But if you assume it's at least a plausible explanation of how those injuries occur, what the officer said, do you think the injuries, the point of entries of the bullets, which don't contradict that story, they might support another story, but there's no witness to say that story happened? Do you think that's enough to create a genuine issue of material fact?
I think they do, Your Honor. And one of the reasons
I appreciate, you know, your whole allegation is that you're, is that the decedent, was wrongfully killed. So, yeah, I realize that puts you in a difficult position to prove your case. But my real question is whether that's somehow an exception or, to the requirement that you offer some evidence that would dispute the testimony of Officer Elliott.
Your Honor, the absence of a weapon goes to that issue. That makes it less.
But how does that really? Because I mean, would he have been able to realize that? I mean, from my view of the couch and the way you've described it, which, by the way, I appreciate that helped us all out. But I mean, that the kind of side of the couch, it makes sense that he wouldn't have had a complete ability to determine it, at least before he turned, whether he had a weapon. And maybe the argument is, well, he turned and a weapon wasn't there. But, given the events before that, that seems like a bit of a bit of a burden. So I'm having a little trouble with the significance of the lack of weapon.
There are really two different issues here, Your Honor. One is whether or not the officer had a reasonable belief, although mistaken, that this person had a weapon. And the other one is whether or not he engaged in the furtive behavior that was described, rooting around the couch. The absence of a weapon makes that less likely. And if I may,
but those are two. Again, I mean, I don't want to convince you of an argument you're not making, right? But those are they're two separate, like, theoretical claims here, right? One of your claims, it sounds like you're saying, is he didn't fear anything because he wasn't making furtive movements, and the whole story from the officer is BS.
Yes.
And that seems hard, right? Because it's hard to see exactly what the evidence for that is, right? You got the just don't believe him story. But the second argument, it strikes me, is an affirmative story, which is, no, my guy got shot in the back, like, full stop. Like, that's the evidence, is that I got shot in the back, not rooting around or anything else, that I literally just got shot in the back.
You're right, Your Honor, and some courts think that that's sufficient in itself to create a jury issue. And I see that my time has expired, unless you would like me to address something else.
Counsel, Mr. Mullins?
May it please the court. My name is Michael Mullins, and I represent Troopers Elliott and Cornelius in this matter. I guess technically at this point only Trooper Elliott, because it seems like the claims against Trooper Cornelius have been withdrawn here today. And as Mr. McCowan made his argument today. I think that he misses the point as to what the law is in a case like this. The issue is, could a reasonable officer have believed, a reasonable officer in the same position as Trooper Elliott, could he have believed that probable cause existed that Mr. Crumbly presented a threat to that officer? And what Mr. McCowan was saying, and I tried to write this down, was that if a jury could have come to a different conclusion than Mr. Elliott, then Mr. Elliott should lose this motion for summary judgment. And that's not what the law is. The law is not whether or not a jury could come to a different conclusion. The law is whether a reasonable officer in the same shoes as Trooper Elliott could have come to the same conclusion. It's an objective, reasonable standard. And when you look
but counsel isn't, don't those two things kind of come together with the law that interprets the principle you, I think, accurately described, with the clarification that you cannot have a reasonable fear that justifies shooting if the officer is, at least has his back to you, unless he's doing, unless I don't know the right word, unless the individual with his back to you is doing something else. Certainly, if he's running away. I mean, so I think that's the point is, and maybe I'm getting it wrong. I don't want to speak for your colleague, but I think his point is, you can't by law have a reasonable fear if Mr. Crumbly is running away or has his back turned, and he got shot in the back, which shows he was shot when his back was turned. And so that's where there's some issue about whether your client's testimony can be viewed as sufficiently uncredible in light of the physical evidence.
And I appreciate the question, Your Honor, and I think that you have to look at the totality of the circumstances when you're evaluating a Fourth Amendment case like this, and you have to put yourself in the officer's shoes on this day in question. And you have to recall that they were told that this guy was armed by the son and the daughter, and the decedent himself told these officers that he was going to get a gun and he was going to shoot them. And he was running back toward the house where he said that he had that gun. And so when you put yourself in the officer's shoes.
Let me ask this question. Maybe this is a way of asking. So assume all those things, and assume the officer said, he said that he's got a gun in the house. And so the guy Crumbly just runs toward his house. And as he's running away, the officer says, I don't want him to get to his house because that's going to make more work for me. And so I'm going to shoot him in the back. Right. And I'm, just pull the trigger and shoot him. Right. That wouldn't be a permissible shoot, right?
I would agree, Your Honor, if he was merely running back toward the house where he said that he had a gun.
Right. But so the point of that is that all of these things that come before doesn't change the fundamental question of whether he shot the guy in the back as he's running away, which is, plausible under the evidence, right? Or what the officer says is true, right? Which was that he shot at him center mass, but there was some sort of spin that he can't articulate or describe very well that allowed him to end up being shot all the way in the back, right? I mean, all the way turned around. That's the part of it to me that's hard is, we've got to take the spin story that your client gives and combine it with the shot in the back evidence and say, in essence, no reasonable juror could conclude that anything happened other than what the officer described.
And Your Honor, when you look at what I believe it was Judge Urbanski pointed out on page 89 of the record, what Trooper Elliott said was that he was turning toward him when he shot. And I think that makes sense with his testimony. He's turning toward him from he basically has his back to him and he thinks that he's getting a gun because he promised that that's where he was going. And as he's turning toward him, he shoots him. And then one of those shots ends up in his back. I think that makes sense.
But
when
in
you think about the
122,
position.
he doesn't seem to, that doesn't, all right, I mean, right, so you turned the opposite way from the way I would have turned, but right, I mean, the oddity, I mean, you've got him turning literally, you've got him turning his back to him, right? Because he's at a couch.
Turning 180.
Right? I mean, you just, to make your story make sense, counsel, you literally turned to 180, which is not, if I look at JA 307, which is page 122 of the deposition, he says he turned toward me. Right? Where was he? Turning towards you, What was it? Center mass.
Yeah,
right?
and it. Go ahead.
I mean, that's what I'm having trouble getting my head around, counsel, is what do I do with that? I mean, I understand that you have a plausible story. Maybe it's a 180 story, or maybe it's what he says, his momentum carried him around and I hit him and he just kept turning. Well, but he couldn't, I mean, if he hit him and then he kept turning, I'm not sure what that means. Anyway, it's hard for me to understand what your client's suggesting here. But how do I take that and conclude that the only factual conclusion here is that he was shot in a spin and not in the back?
Again, Your Honor, I think that someone can turn towards you by turning this way toward you or this way toward you. There's two different ways that you can turn to. If you have your back towards someone, you either turn to
here's
the
the
right
thing.
or the left to face them.
No, because he's facing the A-frame and the couch. This is why the discussion about the A-frame and the couch matter. He's facing the A-frame and the couch, right? And the officer is coming to his left-hand side, right, around the A-frame. So he's on my left-hand side. I'm facing the A-frame, right? I can either turn 45 degrees to the officer, which is what the officer says happens, or I can turn 270 degrees around to go back to the officer, right? You're trying to get him to turn 270 degrees around. He's doing the pirouette like before he gets shot. I mean, that's what doesn't make sense to me.
Yeah, and I don't think that the officer was asked or he articulated whether he was spinning right or left when he faced him. What I think the officer articulated was that he was reaching towards something and that he thought that he was making good on his promise to get a gun. And I think if you look at the decisions that this court has made in similar situations, and I would point the court to the Milstead versus Kibler case. An officer is entitled to qualified immunity when he makes a mistake of law. Here we know, or a mistake of fact. Here we know in hindsight, which is 2020, which is what the plaintiff's counsel wants the court to apply here, and what the court's not supposed to apply in one of these cases. We know that Mr. Crumbly was not armed, but we have to put ourselves in the position of the trooper at the time the trooper made the decision to shoot. And he's entitled under the law to make a mistake, whether or not he was armed. And I think that's what we have here. There's a whole series
that's
of
totally
cases.
fine, right? It's totally fine if he thought he had a gun and he didn't, right? The challenge I've got is that his testimony doesn't seem to match up with what you're describing, right? He says, where were you aiming? Center mass, which is where? The middle of the chest, right?
Mm-hmm.
And then he goes on to talk about, well, if you were aiming at center mass, how in the world did you hit him in the back? Right? And he says, well, I don't know. He was turning. I hit him. He kept turning. I believe. I don't, right? I mean, and then he does say when he was turning, was this part of the turn from the couch? Yes, toward me, right? Which suggests he's turning to the left, not to the right, right? He's turning toward me, not around behind me. I mean, I'm having a hard time understanding. And then I go back to the basic premise is that it's your burden to show that there's no material facts in dispute here. And it sounds like to me, like all I can describe are facts that I don't understand.
And Your Honor, I appreciate your question, and I still come back to he's allowed to make a reasonable mistake. There's no evidence from the other side, from a ballistic standpoint, that would demonstrate that he was shot while his back was turned first. There were multiple shots. We know there were multiple shots that didn't hit Mr. Crumbly. And we know that the trooper says that he was turning when the shooting was going on. And anyone that's ever shot a pistol knows that it's not as easy to hit things as people think that it is to hit things when you're aiming at them. And this is especially true when you have a fear for your life. And so we don't know whether he was shot with whether the bullet that hit him was the first shot, the second shot, the third shot. We don't know which bullet, and we don't know where he was hit in sequence when he was shot. What we do know is that Mr. Crumbly made threats to his daughter. We know that Mr. Crumbly made threats to his son. We know that Mr. Crumbly made threats to the troopers. And we know that Mr. Crumbly was retreating towards his house where he said that he had a gun, and that this trooper reasonably believed, and that's the issue that the Fourth Circuit's laid out. He had a reasonable belief that there was probable cause to believe that he was in danger, and that's why he shot, because he reasonably perceived that he was about to get shot. And the Fourth Circuit law is clear that a police officer doesn't have to wait until he sees that gun to fire. He doesn't have to wait until the other person shoots to fire. If he has a reasonable belief that he's in danger, he's allowed to fire. And that's what we believe that was established below, and what we believe that the district court judge relied on in granting Trooper Elliott summary judgment in this matter.
Is your client's description of the events in this case and the turning and all, is that supported by any expert testimony as to how this turn may have happened and how the bullet wound could go? And in this particular case, back to front, right to left, and downwards. Did you have any expert testimony?
Neither party had any expert testimony in this case. The only thing that would come close to an expert report would be the medical examiner's examination, which is part of the record. There was no ballistics expert hired by either party. There was no use of force expert hired by either party. There was no medical expert hired by either party.
So, counsel, let me follow up with something. So, I mean, to me, maybe Judge Richard and Judge Urbanski, we all look at it the same way. I mean, I think it's fair to say he could have turned either way. I don't think the testimony gives us one indication, one versus the other. But at some point, it does say he got to a point where Officer Elliott was able to at least attempt to shoot front center. And so he gets around to facing him one way or the other, and yet we know he shot in the back. And I understand your client's explanation. I understand he, quite frankly, can't be extra precise given all the chaos and difficulty of the moment. So I'm not being real critical of that. He's given his account, which arguably is, which I think, let's assume, is consistent with the physical evidence. But we got physical evidence that at least could be consistent with your client shooting Mr. Crumbly in the back when there was no danger, or at least no danger that the courts have recognized to be sufficient. It seems to me, I mean, does a plaintiff kind of have to rely on the fortuity of a witness who happens to see or take a video or something? Or isn't physical evidence that's capable of an alternative explanation enough? I mean, speak to that, because I grant it, we got physical evidence that could go one of two ways, at least one of two ways. You got your client testifying a way that I think is consistent with that. We don't have any other witnesses, but the physical evidence itself could be consistent with another alternative. I mean, why isn't that enough? Why do they have to have a witness when, in this case, their allegation is that he was wrongfully, killed? And, I'm not agreeing with that one way or the other, but that takes away the other potential witness.
Okay, and I think I understand your question, and I think that comes back to the qualified immunity standard and the Fourth Amendment standard, where you have to put yourself in the shoes of an objectively reasonable officer in the same situation as the officer found himself here, and that you can't go back and judge these cases with 20/20 hindsight.
And that may be true, but doesn't that law, to put ourselves in that situation needs to be that that Mr. Crumbly's back's not turned to him when he first shoots. Is that right?
I don't necessarily think that's right. I think that his back could be turned to him when he first shoots if that officer still had an objectively reasonable belief that while his back was turned to him, he was trying to access the gun that he told him he was going to go get and shoot Trooper Elliott with. And so I think that's an extra layer of undisputed facts in this case that is important to realize.
It strikes me that that's the speculation, right? So in response to Judge Quattlebaum's question, you're like, well, maybe he had his back to him when he was looking for the gun, right? But there's no, that is contrary to your own client's testimony, right? And so I don't know how you get to make that argument.
Well, I don't think that that's necessarily contrary to what my client said happened. You have this, it's what I would call a patio because it's not elevated, but you have the A-frame. He had been entering into a different door in the A-frame when he was going back and forth to the house earlier. Then he comes around to kind of a door that's on the side where the trooper loses sight of him for a moment. And you have a couch that is running what I would describe as long ways with the A-frame. And so he's, in that situation, unless, this is a fluid situation and something that's moving quickly and rapidly evolving like the courts evaluate. Well, in that situation, someone can kind of have their back to you. They can kind of be to your side as well at the same time. If I'm like this, my back is perfectly to you. If this is where the couch is and I'm like this, well, my back's kind of to you, but so is my side. And so
right, but the problem is the bullet goes in the right upper back, right, and comes out the left, or ends up on the left side, right? So as you just described it, your story would make sense if the bullet entry was on the left back, moving to the right front. But it's the opposite. That's the challenge that I've got. And I understand there's no ballistic expert here, right? But the way you just stood makes sense if the bullet entry is on the left side. But it's really hard to understand how the bullet entry is on the right side, moving to the left in the move you just made.
Right. Well, and again, that is, I understand that, but it depends on whether you're turning this way or you're turning, like you explained earlier, Judge Richardson, in a 270-degree angle. It also depends on when the bullet struck him in the sequence. We know he fired multiple shots in a quick amount of time, and that the decedent was turning at the same time.
Judge Richardson, his time is almost up. Could I ask one more question?
Please, as much as you like.
here's what troubles me, Mr. Mullins, is that in looking at the district court opinion in this case, the order granting defendant's motion for summary judgment, the district court judge doesn't mention the shot in the back. It's just, it's not part of the calculus. If you look at pages 460, I'm looking at page 460 of the joint appendix. The heading, defendant Elliott is entitled to judge a matter of law on count one. You know, I love district judges. They're great. But in this particular case, when the district judge is considering the facts of this case, I don't see any assessment that the decedent was shot in the back. And if you look on page 14 of the opinion, 464 of the appendix, the district court says, given the totality of these circumstances, any objectively reasonable officer could easily have believed that decedent Crumbly presented an immediate threat justifying the use of deadly force. Well, you know, for all the stuff leading up to cutting around the corner of the A-frame, all that's true enough, right? But what the opinion doesn't address, is the shot in the back. The opinion doesn't address the forensic evidence. And in cases like this, I think the law is this, okay? My brethren who are on the Fourth Circuit regularly will tell me. But I think the law is in cases like this where there is no other testimony other than because someone died. There's just one witness's testimony. That the district court is required to do a critical assessment of the forensic evidence. So what troubles me here is that there's no consideration of the forensic evidence in the district court's opinion.
Your Honor, I'm unaware of a Fourth Circuit case that requires the court to do a critical evaluation of the forensic evidence.
It's called Engel versus Yelton. And it says, your good colleague there, Mr. Judge Urbanski, just quoted it for you, right? A court must undertake a critical assessment of the forensic evidence. I mean, he quoted it.
And apologies then for not recognizing that. But this was raised below by Mr. Crumbly as this whole argument about the ballistics and the lack of experts with the ballistics, but this issue was raised below. And so I think that one has to assume that the judge considered it, whether or not it was placed in the four corners of the written order. You know, I can't, it wasn't, but one I think has to assume that if it was raised, that it was considered by the court.
Thank you for that answer, Mr. Mullins.
You're welcome. If there aren't any more questions, I see I'm out of time, and I will yield and just ask this court to affirm the lower court's decision in its consideration of this de novo to determine that there was either no violation of law or that qualified immunity exists.
Thank you, Mr. McCowan. You got a few minutes. You're on mute. Mr. McCowan, you're on mute. We're not able to hear you.
I'm sorry, Your Honor. I have nothing further unless the court has some additional questions for me.
Judges, anybody have anything for him?
I do not. Thank you.
Well, as you know, we would love to come down and shake your hands and thank you in person, but we're not able to do that in these times. But no, we do appreciate all of your help, and we'll take the case under advisement. Judges, y'all ready to go to the last case?
Court, Courtney Moran on behalf of the government. For decades before the district court's injunction, the government, acting pursuant to the Attorney General's discretion, had been conducting bond hearings for non-citizens detained.
Counsel, it might just be me, but you just dropped off video. Judge Quattlebaum, can you see her?
Oh no. Okay, could you hear my audio?
We could.
Okay, I'll just jump back into it. Thank you, Your Honor. The government had been conducting immigration bond hearings for non-citizens detained under Section 1226A, where the non-citizen had the burden to prove his eligibility for release, and the immigration judges could consider any relevant evidence in making a custody determination. Last year, the district court here, without certifying a class, issued a class-wide preliminary injunction creating a categorical rule that non-citizens in Maryland may never be required to bear the burden of justifying their release in bond hearings, and the immigration judges must always consider petitioners' two preferred factors in those hearings. This court should vacate that class-wide preliminary injunction for three main reasons. First, Section 1252 F1 is a jurisdictional bar that prohibits the district court's class-wide injunction because the injunction restrains the Attorney General's exercise of discretion to implement Section 1226A. Second, even if this court reaches the merits of petitioners' claims, Congress has long granted the Attorney General the discretion to authorize a non-citizen's detention or release during removal proceedings, and the Supreme Court has upheld the constitutionality of that detention without ever holding that due process requires the government to bear the burden of justifying that detention, let alone by clear and convincing evidence, nor has it required an immigration judge to consider alternatives to detention or a non-citizen's ability to pay a set bond amount. And third—
So, counsel, let me stop you there. I just want to make sure we're on all fours about what the Supreme Court has done. The Supreme Court has addressed in DeMoore, Section C, and the argument about whether an individualized hearing versus a categorical hearing could be made. And then the court has addressed in Jennings the statutory arguments about A, and an argument that A should be construed in a way that the petitioners construe here, but not the constitutionality of that. And I don't disagree. We can get hints from that, but I just want to make sure we're on the same page. You don't contend, do you, that there's a controlling Supreme Court case on all fours with the arguments made here today, do you?
That's correct, Your Honor. The Supreme Court has not specifically addressed Section 1226A detention and its constitutionality, but it has upheld the Attorney General's discretion to authorize bond or to detain a non-citizen during removal proceedings since 1950, when the statute at that time transferred the discretion to the Attorney General to authorize release or not.
How could it possibly be consistent with due process to require someone who has constitutional rights, is an alien, but has constitutional rights going through this process, to put the burden of proof on them? How can that possibly be consistent with due process? And hasn't just about every court that's looked at it said that it is a fundamental violation of due process to put the burden of proof on the alien? Now, there are issues as to what that burden should be, clear and convincing, or whether or not it should be the preponderance of the evidence. That's even different from what's in the Bail Reform Act. So how can you argue that due process, that constitutional due process allows the government to put the burden of proof on someone who, in very, very often, A, doesn't have a lawyer, doesn't have a right to a lawyer, B, may not speak English, and doesn't have any access to obtaining evidence. How can you argue that's consonant with due process?
A few responses to that, Your Honor. First, of course, non-citizens in removal proceedings are entitled to due process in bond proceedings, but what that looks like is different depending on the context of the proceeding. The Supreme Court has repeatedly held that.
I'm sorry, we're in 1226A, okay? We're in 1226A, and it's silent as to where the burden of proof is. And I mean, I don't know of another setting in which someone who is facing loss of their liberty has the burden to prove that they're not a risk of flight or a danger.
So thank you. Again, the due process is flexible, and the Supreme Court has consistently held that in immigration matters, the political branches, their authority is at its zenith. And so there are certain rules that can be applied in these proceedings that may not necessarily apply to citizens. But in regards to your points about or Jennings being on a statutory question, even there, the court was ruling on the or disagreeing with the Ninth Circuit's interpretation of the pre-removal order statutes as a matter of constitutional avoidance. And even in dissent, Justice Breyer identified constitutional issues with those statutes, and even there, he said that he would require the bond hearings to be held in the normal, with the normal procedures and not the special procedures that the Ninth Circuit had imposed, which included the burden on the government by clear and convincing evidence. The next year,
Counsel,
yes.
could I want to ask a question about how we evaluate the due process issue. The more again, it's a different subsection, but it is talking about substantive due process related to detention, and there is not they don't undertake a Matthews versus Eldridge analysis. They state that a non-citizen has constitutional rights. They state things that would be required for non-citizens or for citizens aren't necessarily required for non-citizens. They look at the problem and the evidence of the problem Congress was attempting to redress, and then they say that if the procedures redress that, it does not need to be in the least burdensome way. And so my question is, most due process analyses I've seen on various issues do use Matthews versus Eldridge. This one doesn't. Do we follow the Damore analysis, or we do a Matthews versus Eldridge analysis?
Well, I think the court should start with the Damore analysis, again, understanding that it's about a different statute, but it still lays out the principles that broadly apply to immigration detention, and it goes through its immigration detention precedent and lays out that even when categorical detention isn't required, the Attorney General has had the discretion to authorize detention or release. But even under the Matthews analysis, which the Supreme Court hasn't even mentioned in an immigration case since the 80s, since Landon v. Placencia, and even there didn't strictly apply the Matthews analysis. But so we don't think it necessarily applies here. But even if it does, in Landon v. Placencia, the last time that the Supreme Court mentioned Matthews v. Eldridge, it emphasized that in balancing the interest between the private interests and the government interests and the procedures available, the courts have to take into account that the control over matters of immigration is a sovereign prerogative, largely within the control of the executive and the legislature. And the court says, quote, "It would be improper simply to impose deportation procedures here because the reviewing court may find them preferable." And the procedures that already exist sufficiently account for the private interest here in being free from detention against the government interest in enforcing its immigration laws in a reasonable manner. The non-citizen has the opportunity to request bond when they're first arrested from the ICE officer. They can then receive a bond hearing to review that determination from an immigration judge. They can present any relevant evidence that may be available to them. And they can appeal that decision from the immigration judge to the Board of Immigration Appeals. And then if they have a change in circumstances, they can request a new bond hearing in front of an immigration judge. So there are several layers of...
I think Judge Quattlebaum's question was, do you think we should apply the Matthews versus Eldridge standard in this setting or not?
I don't think the court needs to apply it. I think that the Supreme Court's immigration detention precedent sufficiently explains that the Attorney General's discretion to set bond should generally be accepted. But if the court were to apply the Matthews analysis, then the procedures are still fully compliant with due process under the analysis. I wanted to also go back to your point, Judge Urbanski, about the weight of the case law. In fact, there's no other circuit court other than the First Circuit's recent decision, a split decision in Hernandez-Lara. No other circuit has created a categorical rule like what the district court did here to place the burden on the government, even in the initial bond hearing. So applying a categorical rule that applies to every single non-citizen who's detained, even if they, as the named petitioners did in this case, have conceded removability, even if they do have a lawyer, as two of the named petitioners did in this case in their bond hearings, even if they are able, they speak English, or of course there's always an interpreter available during the hearings, even with all of those circumstances at play.
I'm sorry, counsel, the Ninth Circuit's opinion in Singh versus Barr and the Second Circuit's opinion in Velasco-Lopez versus Decker also support this proposition that due process is violated when the burden is on the alien. Don't those cases support that proposition, as well as the case that was decided in August by the First Circuit that you know?
Well, I respectfully no, they don't support the proposition that the burden must be on the government at the initial bond hearing. Both of the Second Circuit and the Ninth Circuit's decisions support the idea that potentially after some period of time of detention, then in the Second Circuit in Velasco-Lopez specifically says that potentially at the outset of detention, the government's...
Counsel, with all due respect, Singh versus Barr says the court agrees with the reasoning of its sister courts and concludes that the Fifth Amendment due process clause requires the government to bear the burden of proving by clear and convincing evidence that continued detention is justified at a 1226A bond redetermination hearing. Sure, it's not the initial one, but it's the same principle. And the same thing in Velasco-Lopez. We got three circuits saying the burden ought to be on the government. Okay, and so are there any circuits that say the burden should be on the alien?
So again, in seeing the Ninth Circuit was addressing a specific type of hearing that happens after a certain amount of time when a person has a petition for review that is pending, and so addressing after some period of time, then the burden might shift. So that's also what the Second Circuit said, and explicitly did not address the issue of what burden might be required at the initial bond hearing. But the Third Circuit addressed a petitioner's claim that
because the Second Circuit in Velasco-Lopez, Mr. Velasco-Lopez was held for 15 months without bond. He filed a habeas petition, and the district court required a new hearing at which the United States had the burden of proof He was released on bond, and the Second Circuit affirmed, right? So the same notion, burden of proof should be on the government. Is there a circuit court that says, that agrees with you, that the burden of proof should be on the alien?
So, respectfully, Your Honor, the Second Circuit affirmed on the alternative ground of prolonged detention. It did not address the government's primary issue on appeal, which was that the burden shouldn't be on the government at the initial hearing, which is what our appeal is about here, the initial bond hearing. So, but then the Third Circuit and Borvat addressed a prolonged detention claim from a petitioner under Section 1226A detention. And the Third Circuit held that even after a prolonged period of time, that person due process didn't require a new bond hearing for that person because he had already received the procedures that were available to him under Section 1226A, which include a bond hearing where the petitioner has the burden to establish to the satisfaction of the immigration judge his eligibility for release.
Well, and that's because at Borbat, the Third Circuit said, oh, look, this comes awfully close to reviewing the discretion in deciding to whether to hold a second bond hearing, is awfully close to invading the discretion of the Attorney General, which is a different issue. And that's a different issue. The statute says that the courts can't do that. I get that, okay? But all we're talking about is the burden here.
Right. I think that the Third Circuit's decision is still had to address the procedures that were available to the non-citizen in the initial hearing, and concluded that he had those procedures where he had the burden to establish his eligibility for release. And because of that, because he received the process that was due to him, he wasn't entitled to a new bond hearing even after a prolonged period of time.
All right, now, can I ask you one additional question? I know your time's almost up, but I want to talk about the 1252F class issue, right? Because I think that's a significant issue in this case. Do you believe that 1252F bars the district court in this case from engaging in class-wide declaratory relief as opposed to injunctive relief?
No, it wouldn't necessarily prohibit class-wide declaratory relief. Of course, here we're in a preliminary injunction posture, so that's not an issue right now. And I think that if the court agrees with us that class-wide injunctive relief is barred by 1252F1, then the district court would have to assess whether a Rule 23b2 class could even be sustained based on the potential for declaratory relief alone. Thank you.
Ms. Gonzalez.
May it please the court, Carmen Irina Gonzalez for petitioners. This case is about whether the government can deprive individuals of their physical liberty for months or even years without the basic procedural protections that due process requires. The district court below joined the near unanimous line of cases, including the only courts of appeals to have addressed these particular questions, in holding that before the government can take a non-citizen and deprive them of their liberty, put them in prison-like conditions, pending their removal proceeding, that it has to justify that detention. And all that the injunction does is require basic procedural protections, meaning the government come in and show that the detention is justified either by a reference to flight risk or to danger, and that the government ensure that detention of non-citizens is not happening solely due to their inability to pay. That's all that.
Can I ask a question? Maybe just sort of reveals my background a little bit, but in the criminal context under the Bail Reform Act, there are a whole host of people who have the burden placed on them in a rebuttable presumption cases for their detention. So, various drug crimes, various crimes of violence, there's a whole set of them. And the statute says that in those cases, there's a presumption that you're a danger and a flight risk, and so you need to be detained, right? And so it's in effect the same burden shifting that we've got here. And that applies literally every single day in Judge Urbanski's courtroom and others to have people detained where they bear the burden to prove that as a citizen defendant, they're not a flight risk and they're not a danger to the community. Help me understand why that doesn't suggest that due process is comports with the idea that the burden of proof is not the central inquiry, but instead the central inquiry is notice and opportunity for hearing.
So Your Honor, I would direct the court to the only case that has addressed the procedures, the Supreme Court has addressed the procedures under the Bail Reform Act, which is where these presumptions are set out, is Salerno. And in Salerno, the court does talk about this category of particularly dangerous individuals, but finds that the detention there is justified because that satisfies procedural due process. I apologize. Because the government, after a full-blown adversarial hearing, has determined by clear and convincing evidence that they are dangerous. So to my knowledge, no court has addressed this question of whether, the Supreme Court has not addressed this question of whether the flipping of the presumption under the Bail Reform Act, other than in Salerno, satisfies procedural due process. The courts of appeals-
So let me ask maybe a different way. Under your theory of the case, is that flipping of the burden unconstitutional?
Well, Your Honor, so this is going to be my second answer, which is that Congress itself is setting out what those presumptions are, and it's doing so based on findings about what this particular category of criminal defendants, about their dangerousness, about their flight risk under the Bail Reform Act. It's very similar to the analysis the court engages in Demore in saying the departure from the traditional way that we look at civil detention here is justified because Congress has engaged in this very detailed fact-finding about what's required under these circumstances.
What Congress did here was delegate that decision to the Attorney General, right? And so Congress said, I take it you're saying, well, if Congress made findings and flipped the burden, that'd be okay. But instead they say, listen, we want the branch that actually knows something about immigration to make this decision. And we don't have a non-delegation challenge. So that's a decision that's delegated to the Attorney General. He says that, I want to use the same policy that the Bail Reform Act uses, and I'm going to flip the burden. And it's okay for criminal defendants. If anything, the Supreme Court case law seems to suggest to us that the criminal defendant has a greater procedural due process right than the non-citizen in these contexts, right? So I'm having a hard time understanding why that treatment and that sort of unquestioned use of that throughout the country isn't really a strong indication that due process doesn't require what you're asking.
Well, Your Honor, so I would say actually three answers to that question. The first one is that when Congress enacts the statute that's at issue here, when it amends it just to increase the amount of bail that's required, it leaves the rest of the text untouched. And that text had been interpreted for decades by the agency to mean that the government has to justify the detention. So if anything, Congress—
You brought an arbitrary and capricious challenge?
No, Your Honor, but
the agency gets to change their mind, right? I mean, that's the whole point of this. It's delegated to the agency. That's not answering the due process question, right? Maybe you want to challenge the decision-making process. I don't think you can. That's probably why you're not doing it. But that's the decision-making process. But what it doesn't suggest is that the executive, just like Congress, isn't entitled to make the judgment, just like it's made in the Bail Reform Act, that the burden ought to be allocated in the way it's chosen.
So, Your Honor, that actually takes me to my second answer to that question, which is that even when Congress has been clear that it's delegating authority over the detention matters to the executive, right? The Supreme Court in Salvidas explicitly recognizes the statute uses may, and may connotes discretion. That discretion, however, the court goes on to say, is subject to important constitutional limits, and that includes due process, right?
But counsel, let me, but don't you run into, I mean, the Supreme Court's addressed that case, Zazavas, and pretty clearly said, I mean, I think we can agree about what the court has, whether they've directly addressed the issue before us, but I can't remember, I guess it was in Jennings, I may be missing my cases, I've got a lot of them in my head right now, but they pretty clearly limit that case and distinguish C because we don't have an indefinite period. We have a set point. It may take a while sometimes, but we know this period ends when there's an order about removal. So it seems to me that case has been pretty clearly limited by the Supreme Court to a way it doesn't apply here. And so I don't think the may helps you because the may had no point at which you would know there's an endpoint. Here we don't have a date endpoint, but we got an event endpoint, and it seems like that distinguishes it. And the Supreme Court's, whether you agree with that or not, the Supreme Court spoke on it, hasn't it?
Well, Your Honor, so the Supreme Court is distinguishing there the language where the statute says shall detain under 1226C and comparing that to the language in Zavidas, which says may. And right. The court explains, well, we interpret it may to impose this reasonable limit because, yes, of the indefiniteness of the detention and the fact that you could potentially have someone detained without foreseeable removal. The indefiniteness, however, goes to the remedy that the court grants the non-citizen. It doesn't go to the initial question about whether that discretion is subject to constitutional limits. So in Zavidas, because you're faced with indefinite detention, the court says we're going to read the statute to say after 6 months, that detention, the reasonableness stops being assumed. And therefore that everything, the statute doesn't control anymore. You can go to district court, you can file a habeas and say, my detention is not reasonably foreseeable, you should release me, unless the government can show that I fall into this category of especially dangerous individuals. And this is how the First Circuit in Hernandez Laras addresses Zavidas, right? It says, due process is flexible and it adapts to the particular circumstances. In Zavidas, faced with indefinite detention, the answer was, we're going to impose a reasonable limit. After that time period, that detention, we're going to presume is not reasonable anymore. Now here, the question is, what does due process require here, where we have this, not the criminal aliens that are at issue in Damore, not the post-removal individuals who are at issue in Zavidas, but people whose removability hasn't been determined, people with no criminal records, people who came here as children. And as to those people, can the court detain them for months or even years pending their removal proceedings? And that's the question.
So here's your problem, that you go right back to it. You can't help but say it either. Does the court detain them? It's not the court, it's the executive. The point is that the court doesn't have a role in it, right? What you said is, can the court detain them? No, it's whether the executive can detain them.
Right, Your Honor.
Isn't the point whether the Constitution has a role in this as opposed to whether the court has a role in this?
Excuse me, Your Honor. Yes, I misspoke. Whether the Constitution imposes a limit on the government's ability, in this case, the jailer is ICE, whether ICE can continue to detain them. If you look at Hernandez Lara, the period of detention there was 10 months before the individual was eventually released. In Velasco Lopez, it was 14 months before the individual got a bond hearing that complied with due process and was eventually released. So we're not talking about the 1.5 months at issue in Damore. We're talking about very long detention.
Counsel, I want to ask you what I asked your colleague as to how we go about analyzing this. I mean, a lot of the district court cases and some of the other circuits have done a Matthews versus Eldridge analysis. But the Supreme Court in Damore does not. And I recognize the issue is a different subsection and it's not specifically the burden of proof issue. But it seems hard for me to understand why you would do a different analysis moving from subsection C to subsection A. I mean, there's just nothing about that. And it looks to me like the Supreme Court tells us that in the world of immigration, here's the analysis we do. And certainly nothing's happened since Damore that from the Supreme Court that's changed that. Do you disagree that we should apply the analysis of Damore, where we look to see whether Congress, whether there's evidence that Congress was trying to address, namely whether these non-criminal aliens were a risk, there was a risk of not showing up at the deportment hearings, and whether in light of that, deferring to the agency that had to do that was reasonable or not, and with the condition that it doesn't have to be the least burdensome method. Isn't that the way we look at this?
So Your Honor, I would say actually Damore is not on point. So for two reasons. Yes, the court could look at the court.
You said what?
I'm sorry.
Could you go back? I missed you.
Sure. That Damore actually does not control the analysis here for two reasons. The first one is the government is not arguing here that Congress has set the rules that apply at these bond hearings in the way that it did for criminal aliens under 1226C. And so that they point to a statement about how the reason why individuals weren't showing up for the hearings was because they weren't being detained. That statement in the legislative history actually goes to the desire to increase bed space, not to the desire to flip the traditional burden of how these bond hearings have been operating for decades to now put the burden on the non-citizen. But second, Your Honor, as you were asking the government this question, I actually made a note to myself and said, to me, the case that best illustrates this is actually Salerno. So the defendant in Salerno had two challenges. And the first one is the Damore type challenge, right? Is Congress, as a substantive due process, is Congress authorized to engage in this type of detention? So the issue in Salerno was until the Bail Reform Act, pre-trial criminal detention had to be justified by a reference to flight risk. And the Bail Reform Act changes that. And the defendant in Salerno is saying, Congress can't do that. That's my substantive due process challenge. And the court says no. It looks at the history of the Bail Reform Act. It looks at what Congress had before it. And they say, yes, Congress can constitutionally do this consistent with due process. Now make this detention determination based solely on dangerousness. That's what Damore does. And it's almost exactly the same analysis. It looks at IRA. It looks at what Congress had before it. And it says Congress can constitutionally make this determination for this narrow category of people. It doesn't, however, talk about the procedural due process question. Salerno goes on to do that. So Salerno then says, now there's a separate procedural due process challenge about whether the procedures that are employed are satisfy procedural due process. And it goes on to say, yes, because the government has the burden by clear and convincing evidence. That question doesn't come up in Damore. In fact, if you look at footnote 3 of the opinion, the court is clear, we're not touching the procedures. We're not talking about procedural due process here because this defendant did not go through the Joseph hearing. They did not try to follow those procedures to challenge their detention. So this is not a question about procedures. This is a question about substantive due process. And so, for that reason, Damore doesn't control. And Your Honor, I would say that if the government is right, that all that the court needed to say in Damore was immigration is different. The power of the government to detain here is so strong that we'd look no further. There would have been no reason for the court to engage in the very detailed analysis of the evidence that was before Congress before they passed the mandatory detention statute. The court spends 4 pages of the opinion, from pages 518 to 521, looking at the studies and looking at the reports and looking at the testimony that was before Congress. But that would have been unnecessary if all that the court needed to say is detention is valid during deportation proceedings. That's that. The Congress can do, whatever they want.
Can I ask a slightly different question just to make sure? Mr. Espinoza, can you tell us his status?
Yes, Your Honor. So Mr. Espinoza has, as it's clear from the pleadings, was released after he was granted a new bond hearing following the procedures that the district court had set out. His individual cancellation claim and claim for asylum were denied, and the board has dismissed his appeal. He's currently pending an application for relief from his wife that would make him eligible to move to reopen those proceedings and get status.
Does that, can you just address mootness in light of his current status?
Well, Your Honor, so the district court below actually addressed the same question with respect to Mr. Miranda and Mr. Thompson, because by the time that the order is entered in this case, they had been granted withholding and asylum respectively and had been released from detention. But the court there says the case law is clear that where they're seeking to represent the class for these transitory claims, these individuals who have been released can continue to represent those interests. And there's an amicus brief that was filed before this court.
So let me just ask one more question, and then you can go to amicus briefs if you want to. But so if we found under 1252 F1 that you can't bring a class, then would that mean that your whole case is moot?
But Your Honor, we would ask for
because you no longer have you don't have that class claim any longer?
Well, Your Honor, we would ask for the opportunity to brief that. There's sort of the question about whether they can pursue class-wide, for example, declaratory relief, or whether this possibility of relief from Mr. Espinosa himself means that he has enough of an estate. The government hasn't raised it, so to be honest, we haven't, briefed it or looked at the case law. But I would like the opportunity to address the F1 question, because I do think that the court should proceed to, address the merits and affirm the injunction below, and that the F1 statute doesn't pose an obstacle. First, the government has waived.
Can I ask you just a remedy question? If we disagree with you on this and we find that F1 does prohibit the injunction, what is the correct remedy in that context? Would it be to vacate the lower court decision for violating 1252 F1, or would we also reach the merits?
Again, Your Honor, we would ask for, the government hasn't suggested that there's a mootness problem, so we haven't had the opportunity to brief the question of whether aside.
That wouldn't be moot. That would just say that you can't get the preliminary injunction that you've sought. So the preliminary injunction was invalid under 1252 F1. I know you don't agree with it. I'm just trying to understand conceptually, right? And so therefore, the injunction is vacated under 1252 F1. My question is, in that context, would we stop there, or do we then go on and address the merits? Under the hypothetical that I'm disagreeing with you under 1252 F1. I understand that you have an argument you want to make.
So Your Honor, I would say the reason why I'm referencing back this question of mootness is because if the court looks at the decision in Hernandez Lara, that decision is just about one individual. And so to the extent that there are plaintiffs who continue to have an interest, either in their own cases or because they can seek declaratory relief on behalf of the class, then that would permit the court to answer the merits. But again, we haven't briefed it, and we would ask the court for the opportunity to do that. If the court would just permit me 2 quick points about the F1 question. Sure. The first one is that we set out in our brief, the F1 provision is not a jurisdictional provision. It goes to the court's relief power and not to the court's subject matter jurisdiction. And the government here just failed to raise it. They don't raise it in opposition to the PI. They don't seek a stay. They don't seek for reconsideration on the basis that the court ruled more broadly than they were expecting. They don't even put it in their docketing statement when they file a notice of appeal in this court. It's not until the opening brief that the F1 issue makes its appearance. So it's not jurisdictional, and the government has unquestionably waived it. But if the court reaches the merit, I would direct the court to the DC Circuit's decision in Grace versus Barr, where, I think that one of our main arguments about why F1 is not an obstacle here, the court there is clear to say, F1 talks about injunctions that enjoin the operation of the statute. So a constitutional challenge to 1226C, for example, saying, for everyone in a class after a certain amount of time, you have to give them bond hearings, mandatory detention no longer applies. That's clearly an injunction that enjoins the operation of the statute. Here we're talking about agency procedures that are not set out in the statute. So under the government's view, if the Attorney General here had said, we're going to decide bond hearings under 1226A by flipping a coin, An injunction against that would, in their opinion, enjoin the operation of the statute. That's nowhere set out in that statute. That's clearly not what F1 was meant to address.
Thank you, counsel.
Thank you, Your Honor.
Ms. Moran, I think you have a few minutes.
Thank you, Your Honor. On 1252 F1, the government did brief this in response to the petitioner's motion for class certification before the district court. The district court decided not to rule on that and instead granted class-wide relief without addressing the motion for class certification. So we did raise it below. It is also a jurisdictional bar, as the Supreme Court plainly said in Jennings v. Rodriguez. 1252 F1 does not allow any lower court the jurisdiction or authority to grant class-wide relief. Class-wide injunctive relief. And the injunction here does restrain the operation of the statute because this statute gives the Attorney General the discretion to release or detain someone during their removal proceedings. If a district, and Jennings was clear about what 1226A means in its decision, and so any injunction like the court's injunction here that goes beyond that is affecting the operation of the statute and is barred. We don't think that the court necessarily needs to rule on that, though, to vacate the injunction, because on the merits, Salerno, another point from Salerno discusses that to prevail in a facial challenge, which is what petitioners have brought here, and what the district court's injunction is not. It's not about prolonged detention. It's not about someone who is fighting or necessarily fighting their removability. It applies even where a non-citizen concedes removability, like all of the three named petitioners did in this case. It applies where they're to their bond hearings that happen just a couple of weeks after they're detained. And the Supreme Court has never required those kind of procedures in the immigration context, and no other circuit court other than the very recent split decision in the First Circuit has ever required that in the initial bond hearing.
Mary, can I ask you a question? Following up on something that Judge Richardson asked Ms. Gonzalez with regard to the Bail Reform Act, which is where Judge Richardson's exactly right. We deal with that in the district court. I was magistrate judge for 7 years, so I did bond hearings for 7 years. I can quote Salerno, but isn't it fair to characterize the presumption of detention for violent felonies and drug offenses that carry a 10-year a sentence of 10 years or more, which is where the presumption is in the Bail Reform Act? Isn't it fair to sort of characterize that as the same sort of class of characters that would fall under 1226C? And so that, and 1226A is different. These are folks who aren't charged with crimes, and there are folks who wouldn't, under the Bail Reform Act, have to bear the presumption. So isn't it fair to sort of put the folks who have the presumption under the Bail Reform Act in with the 1226C folks and treat them differently from the 1226A folks, and the other folks who under the Bail Reform Act don't have to rebut the presumption of detention?
Your Honor, I would respectfully disagree with the premise of the people that are detained under Section 1226A have not been charged with crimes. Two of the named petitioners here were charged and convicted of crimes, including assault and driving under the influence. So even if they're not subject to mandatory detention, it's not necessarily that they are that they have not committed any immigration violations or they don't have any criminal violations. And again, that is why the scope of the district court's order that—
Ms. Moran, fair enough. I agree with you that they may have committed some other crimes, but they didn't commit a crime but fell within the level of 1226C, right?
That's correct.
Counsel, can I just follow up, Judge Richardson, to finish out, maybe this point. And this is where I think, and your colleagues, responded to this and has some points, but I still think there's a question of, D'Amour's Damore's applicability, if not controlling, is instructive. I mean, to follow up on Judge Urbanski, it might have been better. I mean, it is the response there that it might have been better and made sense, to have the burden only on the subsection C non-citizens. But Damore doesn't say we have to have the least restrictive means or the least burdensome. We have to have something that addresses, the problem that is articulated by Congress. And again, your colleague is right that there's a lot of stuff about the criminal non-citizens, but that I've read a lot of that, a lot more than I ever thought I'd be reading of a committee report. And I mean, I think it's fair to say there's there's findings in there about non-criminal non-citizens showing up as well. So I guess my point is, if the question is what's the most reasonable way you might do one thing, but is that really our job as an appellate court?
No, it's not. It's not your job your job or the district court's job, Your Honor, to assess what you might prefer as a policy matter. And Damore, as you said, says that the government need not use the most or the least burdensome means to accomplish its goal of preventing flight and dangerousness during removal proceedings. If you'd permit me another second, in Damore also it discusses the Supreme Court's decisions in Carlson and Flores, where before the 1996 revisions in the law, and in those cases they discuss the Attorney General's discretion to detain or release. So that's been consistent since 1950. And in those cases, the Attorney General, not Congress, the Attorney General made a decision to categorically detain members of the Communist Party in Carlson, and then through regulations that were addressed in Flores, made a decision to categorically detain juveniles who were or who entered without family members, and then not releasing them to non-relatives absent special circumstances. So the Supreme Court's decision in Damore, again, does not exactly address 1226A, but it does detail the Supreme Court's case law in this area that we think shows that the procedures that already existed sufficiently satisfy due process, and there is no support for the type of categorical rule that the district court created here to place the burden on the government in every single bond hearing, and to require considerations of the two factors that petitioners prefer. So we'd ask this court to vacate the injunction. Thank you.
Thank you, counsel. Obviously, we would love to come down and greet you, and thank you both for your excellent help on this case. We'll take it under advisement, and we'll recess for the day.
Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.